Yesterday. We don't remember. What is the issue? Okay. So now when it is, I don't remember because yesterday many orders we have signed. So what to do? You come up at 2 p.m. Let us see. You come at 2 p.m. And in the meantime, you may inform the. 6.
Monday, Mr. Mukherjee was that side. I could not read the quote by US government that we have refused the adjournment and that posted the matter after 3 weeks.
Oh, that matter where second day adjournment was so.
Also, I could not reach, and secondly, it's my fault. But
so what can be done? So what will happen? Let it come after 3 weeks.
I don't know what to tell you. That's the reason why.
If there is something which will happen in the meantime, we can understand. Otherwise, what is the big deal?
My title is starts of promotion because of a disciplinary proceeding which we challenge.
Promotion is never a urgent matter. Everything you will get when you get it. Everything can be given. You have to prioritize your case as per your. So if you have not prioritized, why you are asking the court?
My fault. I'm saying that
3 weeks is not a long time. If it had been a long time, we would have understood. He can wait for 3 weeks. We don't want to encourage these things. We don't want to encourage these things. We are being very clear. You have your priorities. You have decided. Now, what is the big deal? If there is something we can understand that is something is happening tomorrow, if it is not taken up, in that case, whenever may be the date, we will take it up. We may take it up. But if there is no precipitatory action being taken, which requires consideration immediately, why can't you wait for 3 weeks? That's not your fault. That's not your fault. That is a professional.
I was arguing in a court. I couldn't leave that matter and come with it.
That's something to be sorry. You think I have not been that side? It happens. It happens. What's the big deal? That's what we are saying. You prioritize. We also used to prioritize. You have prioritized. Again, we are saying something is happening. You can mention. You can bring it on record. 3 weeks is nothing. It will be taken up. We are all the matters now which are on list are almost being taken up every day. It's not that it will go much down below on the list. Wait for some time.
With the leave of the Honorable Justice Vishwas, my lord, a matter was first appeal was assigned to your lordship, my lord. I have filed one application for early disposal of the appeal, my lord. I am the decree holder. So that application may be included in the list, my lord. I mentioned the matter last week, my lord. So
no, you are mentioning before his lordship.
No, lordship.
Oh yes, sorry, I thought he was hearing. Yes, what is the mention?
Mentioning was a application for early disposal application. This is for early hearing of the first appeal, my lord.
First appeal.
First appeal assigned to your lordship, my lord.
Did you give the slip? We'll see when it can be done. Wait till the bench is available. Yes. So what? It started, it is started. Nothing is going to happen till first. Yes. So it is started, that means your appeal has become infructuous. So if any order is passed for depositing the money, you may come. Yeah, that's what it is.
Lordship, may I be permitted to mention a matter for inclusion? Urgency is that, Lordship, I am appearing for union and the respondent is charged with Rule 153 of RPF Act. Against such a charge sheet, they filed a writ petition and writ petition disposed of. And the disciplinary proceeding initiated by the appellant authority and um, Lordship, disciplinary proceeding initiated and due to dismiss for default of a writ petition filed by the respondent, the disciplinary proceeding could not be initiated. Lordship, kindly take the matter as urgent.
It is for restoration.
This is for restoration.
Application for restoration.
No, Lordship. Restoration application filed in single bench by the respondent and the order passed and the writ petition already restored. Against that order, we prefer to appeal before.
Against restoration, you have preferred appeal. For you are appearing for the Union of India. Take the slip next week.
My lord, may I be permitted to mention this Group 3 appeal? My lord, the interim order was extended by my lord's bench on 7th of November till 21st November. My lord, since the my lord bench is not sitting, my lord kindly extends.
Will have to be done.
That I am. You inform the other side.
My lord, I have notified them. My lord kindly keeps it tomorrow as to be mentioned. I shall give a
Yes.
further notice.
Day after. Friday it will come.
My lord, Friday it is expired.
Okay, tomorrow.
For-
The first.
Item number 1.
For one, I'm led by Mr. Kollol Basu is appearing online, perhaps.
Yes.
So, my lord, I was told he'll be appearing online, but he's not there. My lord, kindly grants us an accommodation. Apologies, my lord. বলুন না, আপনি বলুন।
এটা দিয়ে দিন যে ওয়েটা ফাইল করেছে সেটাই ওইটাই
The main thing is that
liberty to file an affidavit.
that should be brought to your lordship's notice. And what they have submitted, what they have, what was their apartment, they have not annexed the application
Oh, yeah.
file there.
ওইটা লিবার্টি চাই
Liberty,
ওই সাপ্লিমেন্টারি এভিডেন্স
5990 order of
Where is the representation? 22/8/24 representation.
page 84, lordship. Page 84. 84 presentation ছিল। তারপরে 89 90 হচ্ছে আমাদের order of rejection। Terminal order 495।
Yes, finally he has been able to join. Yes,
My lord,
yes.
in this matter, my lord, the original applications, as that were filed before the tribunal, my lord, have not become the part of the record, my lord. That is why I instructed my junior, my lord, that pray for accommodation so that I can, my lord, annex it, my lord, by of a supplementary affidavit. Because I told him, my lord, that your lordships always, my lord, intend to, my lord, go through the way whether whether we are taking a different plea in the High Court, which were not taken before the tribunal. For the sake of transparency, my lord, we should annex it, my lord. That is what I
So
have instructed.
because we are taking such a view, it is required, or otherwise it is required to be filed with the OA.
My lord, it is required since your lordship says it is so. Because we are under a constitution which your lordship says that is we take it that
Otherwise,
your
what is the
lordship-
provision in the appellate side rule? Have you seen?
my lord, all records that my lord, records that were my lord, used before the court below, all should become a part of a paper book.
So anyway, it has to be annexed. It's not that because we want it to be done.
No, no.
So
My lord,
therefore, when we are discouraging this practice, that anyone wants to file a supplementary, they should, at least if they are taking such a casual approach while filing, then maybe
I
something
have
be
come
paid to
across
the.
this, my lord, yesterday. Yesterday, this petition came to me, my lord. I instructed my junior
No,
that
we are
this is
not
a
telling you, you have not filed. We understand that. We understand that. But this is not done. This should not be done.
yes, my lord.
And not because we want it. You are obliged to file it that way. Don't say that this bench wants and this determination wants. We don't know why the stamp reporting is not being done as per the appellate side rule. All the matters are being listed. We see illegible documents, paging not in order. Everything is disorganized.
Yes, my lord.
So that is
My lord,
something.
I tender my apology because this mistake, my lord, I noticed this mistake tomorrow, my lord, yesterday, today, my lord, and I immediately instructed. Yesterday, this brief came to me, my lord. I could not, my lord, go through it in the morning, my lord. I instructed my.
Ultimately, it only facilitates consideration of your case if everything is in order.
Yes.
If you are kind to us, then we can appreciate
No,
better.
my lord, I'm
Otherwise,
sorry, my lord. Kindly do not embarrass me. I'm sorry. I tender my apology.
yes.
But it was the situation was beyond my
All right.
control.
When will you file it?
My lord, Mr.
Within
Jayanti,
1 week. Within 1 week.
As paid.
I'm sorry, my lord.
One week, one update.
Item number 2.
I am appealing for the petition. Lordship, it is the matter where this main issue was whether cutoff marks of OBC B category can be higher than the general category. I argued the matter on the last day. Lordship asked the other side to explain
Page 78,
Yes, Lordship.
Annexure D.
Yes, Lordship.
Just have a look at page 78. That is the page.
Yes.
How much? From where do we get this? Oh,
Same document, Lordship.
71. So this is of no consequence to you.
Obtained 71.25 marks. She got it, serial number 1. That he
You have got less than yes.
71.25 marks.
Yes.
Where is that he should have to apply. You are giving 10 full marks. Then 81.25.
That's not the point.
OBC.
What is the cutoff marks for OBC?
Cutoff marks for
Page 78.
in final OBC 87.5.
Hmm?
In final 87.5.
Where is that?
I don't know, but remember that was the mistake. But they are that he should be allowed to appear in the email. We are allowing the email vote and giving 10 marks, 2 marks. 10 is not coming to the journal hall.
No, this page 78 is the marks for participating in the PET.
But preliminary, it's called preliminary.
Preliminary. Correct. So PST or PET, whatever you call it, it is the cutoff marks for for the candidates for participating in the PST or PET, which comprises of 10 marks, according to you.
No, this the cutoff marks of the candidate PST and PET physical absenteeism.
Yes.
By walking 25 kilometers walking.
That's not the point. So this cutoff marks, how the OBC cutoff marks can be higher than the unreserved.
But ultimately, in the final marks, cutoff marks for all the categories, general category was higher.
So this is permissible that at earlier stage it can be higher and in the final it will be less.
There may be some mistake, but ultimately in a fundamental list, and assuming that we are accepting that his prayer is that he should be allowed to appear in the interview. We are allowing him to interview board and giving 10 marks, full marks.
Then he will get 81.25.
81.25.
And what is the final cutoff? Where is that?
Lordship, the issue was whether it is permissible. In the written test, he could not succeed because the OBC cutoff was higher than the unreserved.
That's
Had
what
it
he is
been-
saying.
Yes,
Even if
had
they
it
allow
been-
you, even they accept you to have qualified, at best you will get 10. That is his argument. You will get 10 more marks. You will still be out of the fray.
No, we will allow him.
So it will be a futile exercise. That is what he is saying.
We will allow him the interview board.
And give him full marks. Then also he will not qualify. That is what he is saying. Therefore, no, but where do we get the final cutoff of 87? Where is that?
Prayer is before the tribunal page.
This is not on record.
No.
You give a copy.
Page 24. There be. You are allowing him and giving him full marks.
So it has been dismissed only on delay. The tribunal has rejected only on the ground of
Yes.
delay.
May I rely on a judgment, Lordship, in a matter? Supreme Court has said that OBC cutoff mark should be 10% below than the unreserved category, Lordship.
What a time.
Even in the final examination, the cutoff on unreserved is 88 and cutoff of OBC is 87.5.
And apex court has said in every case it has to
Not
be
in
10%.
every case, Lordship, but I've got a judgment where
So therefore, a cutoff fixation of a cutoff is a very meticulous exercise that cannot be done.
Number of candidates
Many
qualified.
things are.
had he be
It cannot
qualified,
be a law that it has to be 10% below the.
Lordship, had he be qualified in the written examination, he would have competed with the other candidates.
Do not dispute 71.25 marks granted to you. There is no dispute on that aspect.
No, Lordship, but only the thing is
Therefore,
how they have.
do not dispute the final cutoff marks. Only the written, that is in dispute. Now, if we allow this and say that yes, what you will get? Should we exercise our exercise in jurisdiction in futility? You will not get anything. Your marks are so low that even if we hold that you should have been taken to the next stage, and he's rightly pointing out, if you are given 10 marks, still you will get 81 marks, much below the cutoff. So exercise in futility, no point. Yes, take down. Give which judgment you want to show. This is maximum. This is maximum. This is not that it has to be 10. Okay, this is the maximum. Heard learned advocate for the
Item number 3.
Hopun Banerjee is appearing for the state in this matter, my lord. I'm praying for an accommodation of 1 day on his behalf.
All right. 1 day, not today. It will come on Wednesday now. Next Wednesday. It will come on next Wednesday. Anything which is not today will come on next Wednesday. Will not come tomorrow.
Item number 4.
I am appearing on behalf of the petition on the last occasion when matter was heard, your lordship directed to place some judgment in terms of division bench order.
But I am led by Mr. HON'BLE.
Order for its judgment. Relying upon Surajit.
Have decided this issue in another case. Oh, yes. And we have on the same issue.
সুরজিৎ রায়টা দিয়েছিলাম ওটাকে রিলাই
So your case is that the criminal proceeding is not in connection with service.
service and known excess and there is no pecuniary loss, my lord. And relying upon Surajit Ray.
Criminal proceeding is under which provision? Which section?
302 and 304.
302.
My lord, page 51.
Huh?
Page 51, impugned order. Art Mr. Khan landed at
Page
51. Order was by State Administrative Tribunal.
এই একটা অর্ডার শিটের পুরোনো কাগজ দে না, পুরোনো অর্ডার শিট।
Yes, you have seen the judgment.
Para 16, 17.
Have you gone through the judgment?
Para 16, 17, 18.
Precisely same issue has been decided and we have decided.
Yes, Maharaj. Relying upon Surya.
But I am led by Mr.
Yes, yes. No, no, no problem.
But yes, I have gone through that. ঠিকই আছে। আমার
Judgment
দি-
is a
হ্যাঁ?
You may see this judgment from paragraph 16 onwards. 16 onwards.
Yes. Paragraph 10 is 18. But 16, there is, my lord, no scope to make any departure from this. Because provision is such, so, and the plain reading of the provision is that regarding pension. So
Pension in 14
pension is
and gratuity in 10 only in case of a loss.
yes.
Therefore,
Recovered. Yes.
so we have to go by this judgment. Yes, take.
this report that I received today itself, that the criminal case is still pending, charge sheet filed, but the hearing is continuing.
We have not said it has concluded. We have said the case is
So there
pending.
is no necessity.
There is no necessity.
Grateful lords. নামগুলো দিয়ে দেবেন দাদা grateful lords.
Item number 5.
My lord, in this matter, I appear on behalf of state. My lord directed the state respondent to file an affidavit. But when state has no role to play, because of the reason, my lord, the coordinating bench of the division bench directed the learned tribunal to hear out the application by the single judge. But the single judge has ignored to hear the matter. And that order of the division is still existing. 2023 order. The further is that the further one application has been filed. When that order of the learned the honorable Malad division is still existing, which is Malad at page number 332.
So first thing is you don't want to file a opposition.
Because the tribunal
Because comes later. You don't want to file opposition. That we will record that you don't want to file opposition. Now you proceed. Now yes, let us hear.
Initial issue was, Lordship will have a look, why this
At the very outset, it is stated by the learned state council. It's still pending.
This was still pending. And subsequent thereto, if your Lordship kindly have a look at page 332 for once, this will make the situation lucid. 332. 332 of my application. It reveals that time and again matter was slotted, heard, and refixed. It never being heard. 2016, the application has been filed. And today we are in practical in the 2026. Nothing has been done in spite of I am being successful in all the matters which are filed in the High Court, even up to Supreme Court. For a kind producer, Lordship kindly have a look at page 332 for once.
Yes.
Lordship was found.
So already there is a direction.
Already there is a direction. Kindly make a note of the date when this direction was passed. This was 2023. Now, kindly make a mark of this. If your Lordship be with me on the order that on 335, that it has been fixed on 12th of July as indicated by my Lord Justice Tandon. Now, let us see what happened on that particular day when this matter was posted before the tribunal. The very next page would reveal. Every matter, around 50 writ petitions have been filed, tested before the division, retested before the Supreme. I mean, successful everywhere, implemented with the orders. This is being kept pending for no reason whatsoever. Now, let us read the order, which is 12th of July 2023, 336. And it counts the Lordship's House. The very last line indicates learned counsel for the applicant refers to an order of the Honorable High Court dated such as submits as directed by this court. The matter may be heard and logical conclusion reached by the tribunal within 1 month. The tribunal expresses inability to hear out and conclude the matter within a month for the reason such and such. This was indicated before the court. Pursuant thereto, the order was passed. That you give some precedence to this matter. Now, this was reposted on 15 December. From July, it jumped to December. Now, let us see what happened in December. The very last page of my application will reveal. There is no dual member over there.
15 December.
15 December, very last page. Very last page. Which was found? Sometimes he says, I'm not in a position to hear out as I'm a single member. Sometimes a dual member is required in order to hear out the issue. This was the December order. Thereafter, matter was taken up just prior the other page on 2024. Now he says, I'm a single member. It involves various questions of law. Therefore, I'm not in a position to hear it out. I'm really in a mess, my lord. Good, bad, indifferent, there should be something. Then once again, he is of this view. This is going on from 2016 onwards. In fact, the very last order, Lordship will find, is a 2025 May order. I'm sorry, my lord, I think this missed out my pagination. This, since let this matter be placed before a bench comprising 2 members. This will never be, because since there is no 2 members. This is coming to an absolute natural death. And without my pension and without my anything, no retirement dues, nothing. I could not. Till today, we are armed with only a single member over there. Practically, it's a tribunal by name. It's an absolute non-functional. What I am beseeching before the court, my lordship, kindly hear me out. I have got a good case out here. In fact, if your lordship,
That order is existing. By the Honorable Division Bench.
But what steps have you taken after 12/7/23?
12/7/23.
Yes.
Prior to that, lordship kindly turn the just prior page 24. Just
Come to order of 12/7/23.
23.
Fourth paragraph, fourth and fifth paragraph.
12/7/23 of the tribunal's order.
Yes. Page 336. You have just shown us that.
Just 1 minute, Banda.
What have you done? This paragraph for 4 and 5. Fourth and fifth paragraph at the first page.
These things have been done.
Where is that statement?
These things.
Where is that averment in your writ petition? Where is that averment in your writ petition that all this has been done, still it is not being taken up? Just show us.
No. As regards of lordship will find all the papers are clubbed together. Or if your lordship
Please show us where this fact is. It's an issue of fact. There's no argument or submission to be advanced. And in absence of that, how the tribunal could have proceeded?
No, thereafter the matter appeared.
When did you take steps in terms of this order? We are just asking you. We are not able to find, we have gone through the writ, therefore we are asking, where is that fact mentioned?
Yes. No. As per the original prayers are concerned, there is no modification. We still stick to that. We
don't know.
Original prayers are not being modified.
You said you wanted to modify, you have taken liberty for modifying the prayer on the ground of maintainability raised by the respondents. After that,
Here there is no question of maintainability issue was by your lordship.
No, it is there before the tribunal. You have made a prayer before the tribunal that because an issue of maintainability is being raised, I will modify my prayer. Thereafter, have you taken steps? If not, how the tribunal could have proceeded, or how you are in a position to say anything why the tribunal is not proceeding?
No. Suppose
if you have not taken steps after making such a prayer recorded in the order, then what is there to be heard?
These I can withdraw because there's no.
When did you withdraw? Where we are asking you, did you at any
lordship,
subsequent
kindly
stage?
take up next matter.
At any subsequent
Next order.
stage, have you said that we don't want to file any modification?
Application.
We wish to proceed as it is, or you have filed a modification and still the tribunal is not hearing you? Where is that fact?
Lordship kindly takes up my order dated 14th May 2024.
Which page is that?
This is just prior to that last order, last page. I'm just missing out the pagination for 2-3 pages. Because it's on. In fact, Lordship kindly have a look at the last page itself. This was after the order.
Where is this fact as to what steps you have taken pursuant
With
to
regard
the
to that particular.
Yes.
I have not done because it is not required. I subsequently.
So when did you ask the tribunal that you need not wait for that? We may proceed as it is.
Yes, that is the reason why this order is passed.
There is no such thing on the record.
No, Lordship kindly have a look. What is the order being passed on 15th of December 2023? Kindly have a look. The matter was taken up by the single bench. Lordship kindly have a look. On consent of the learned councils. That means that is given a go by.
We don't know. We will not go by such inferences.
No.
There is a specific there is a specific prayer recorded by you. When you are faced with an issue of maintainability, you say, I want to modify my prayer.
Subsequently, it has been.
Thereafter, either you are required to modify
or not
or
required.
tell the court that, look, we want to proceed as it is.
As it is.
We will take the risk. We will meet the issue of maintenance.
Yes.
We don't find anything of
But
that
it
kind.
has been stated, Lordship, kindly be on consent of the learned counsels of the
Which
party.
date?
This is 15th of December 2023, the last page.
That consent is, second line is in every order. That means nothing.
No.
In every order, the second line, second paragraph, you will find the same thing. You see any order, pick up any order of the tribunal. That doesn't mean that you have waived your liberty to file a modification.
Now, thereafter, if Lordship kindly turns up the earlier next order itself, 14th of May 2020.
Again on consent, every order.
But what is the main issue? This is not the issue.
What we are asking you, either you have to.
Lordship may take up with the issue. I am not onto that modification.
We have to. We cannot ignore it. You have made a prayer.
Give my
You are alleging that the tribunal has not proceeded.
When this,
and we find that your conduct is that you have told the tribunal you have done something, you have not done it.
No, when it is being
then
passed,
how can you make such
when
an
it is
allegation?
being passed, kindly have a note. When it is being passed,
Yes.
it is being passed even after 8-9 years. When
That
it is
is
being
on
passed.
your prayer, Mr. Counsel. That is on your prayer. That the tribunal has not cast upon you. Being faced with an issue of maintainability, you have asked the tribunal to allow you liberty.
There's no question of maintainability. It's
We
only,
don't know. We don't
in fact,
know.
the order doesn't reflect
That
as such.
order is accepted. It is an admitted order, never assailed by you, never withdrawn by you, never recalled by you.
No, Lordship.
So now you cannot say.
Present,
Yes.
and Lordship may take it as present as it is. Then Lordship.
Correct. So therefore, once you have, therefore, no. Why should we hear? If you are not taking steps before the tribunal, why we should take it up? When you say you will do something and you don't do it,
on the subsequent orders being passed. It
Very well.
reflects. It
That's
reflects.
all then.
Subsequent orders being passed. It reflects that it is not.
We are giving. See, you say the tribunal is not passing any orders. It is not considering your case.
And if you Lordship, be with me for 1 minute.
Now,
Ignore
just a
that
minute.
aspect.
You need not say the same thing 3 times. You have already said it. That the tribunal is not proceeding with the matter. Despite the court's direction, it is not proceeding.
If your Lordship do ignores that
You have asked the tribunal to allow you time for meeting the issue of maintainability by filing a modification. Now you fail to take any steps. And you are casting an aspersion on the tribunal. So you were required to tell the tribunal that you please proceed.
That is the reason why subsequent orders were passed.
No, there is no such thing. There is no averment to this effect
No,
either in
if
your
there
writ
is no-
petition, nor the records reveal that at any point of time you have asked the tribunal that we don't want to file a modification.
If
we
a
will proceed
certain
as-
statement is not recorded by the tribunal, can the litigants can be placed at fault?
Yes, surely.
Because
Surely, and that is not an issue which you can raise in a higher forum. If something is submitted and not recorded, you are required to tell the
I am
tribunal.
not onto anything. I am only before this court with a simple prayer.
No, your
Lordship,
simple
I am
prayer
being
is
heard for 10 years.
The whole premise of your prayer is that tribunal is not proceeding with the matter. Now, therefore, we have to see whether the tribunal is not proceeding with the matter or you are also responsible. When you ask the tribunal for liberty to file a modification and you take no steps thereafter, what the tribunal will proceed?
They
How it will proceed?
subsequently.
It has not. It
It
has
is
only
not
passed.
stated since you have not filed the modification, we are not proceeding.
Can we shut our eyes to this record?
If I don't choose to file.
So therefore,
That's
you may. That's we are saying. You could have told the tribunal, let us
that
proceed.
has been done. That is the reason why subsequent orders has been passed to this effect. If they
No,
are
sir.
not recording that,
Any such order you show that you do not want to file a modification, you are requesting the tribunal that
regularly these orders are being passed in a way I am a single member, I can take up. Subsequently, matter is being listed. I can't take up. There's a
Therefore,
huge issue.
when have
Where is
you discharged your obligation or you have complied with the liberty which you took from the
That
tribunal?
is the reason why this order was passed. Otherwise, that order would have been passed. Since you have not filed the application, I am postponing the matter for that reason. No, there is no order of such nature.
All right.
Kindly be with me, my lord. We are poor litigants, poorest, lowest rung in the ladder.
Maybe that is
But
not
if-
that is not the issue. The issue
But
is
that's not the issue.
whether a writ court will
heard.
whether a writ court will usurp the jurisdiction.
The doors of the court matter, let me be heard. I'm not being heard anywhere.
Correct.
All the matters I have done I have been successful. I have. They have,
No, the
but
other
this is the
matters,
reason what
other matters are not before us. We are not concerned with the other.
Mr. Lordship, kindly allow me to come up with the events. We've compiled whatever matters being heard, whatever issues have been settled. Issues have been settled up to Supreme Court. Only I will take 10 minutes, my lord. If your lordship is not hearing me today also, I have to go back. He will be not in a position.
We cannot review the order passed by a coordinate bench.
What let us see what was the order of the coordinate bench. What has been done thereafter?
The coordinate bench has said that the tribunal, you should decide it within a particular time.
True.
It has not proceeded.
It has been proceeded.
It has not proceeded.
It has not. It has been proceeded. What is the language? Can you have a look? Can at least let me make my conscience clear.
This is even the coordinate bench was careful enough to say that we hope no direction was passed, and that you have got the order. You read it, please read it. We hope and expect.
We expect and hope.
Yes.
That this learned single member shall take up the instant matter on the date so fixed and endeavor. Now, this is important.
Correct.
Shall be shown to bring the litigation to a logical conclusion. Then what is the what is the cause of passing this order?
Therefore, when we are examining whether the tribunal is fault for the procrastination or not, we have to see the records. The records show that you have taken liberty for filing a modification. You have not done anything.
No.
Then how they will proceed?
Even that, on that issue, dismiss my matter. At least I can come over here. This issue will
That's not the point. That's not the point. Is whether you can cast whether you can cast aspersion on the tribunal in view of this conduct. That is the only issue before us. Not whether it is to be dismissed or allowed. That is for the tribunal to do.
This was not the issue. This was not the issue at all. Man, kindly be with me on the very next day when the order appeared, when the matter appeared before the tribunal, when this order was placed before the tribunal. On the very outset, he says, I am unable to do so.
But that does not erase. This order will remain as it is. 12/7/23 remains an order on your asking. But that is not done. That's not erased.
Not in a position to hear out. Now, this is blowing hot and cold at the same time.
That is precisely what we are telling the petitioner.
But what
you can't say both. You can't ask the tribunal for a liberty to do something.
Before the court, what we will do.
Anyway.
Even if today itself lordship is thrashing me out, then I'm giving a natural death.
There is no question of thrashing anyone out. The question is of a jurisdiction which is vested in a tribunal, and we know the limits. And you have got an order recognizing those limits earlier. Can we go a step further?
This will never be heard.
We don't know. We are on the legalities. Just because a matter is not taken up, the High Court should start taking it up.
Today itself.
That is precisely what the coordinate bench held. You could have challenged the coordinate bench order.
Can you be with me one minute? It was directed on the single judge to come with a conclusion. On that, even the order of justice.
There is no direction.
It is functioning on one member.
There is no direction. It is an expectation that. Yes.
On whom? On the single member. And now single member says, I am not in a position. What we will go.
Therefore.
We cannot frame a court and decide the issue.
Therefore, we are saying whether it is the fault of the tribunal or you are contributing to that. That is what we are looking. That's why we are seeing an order of 12/7/23.
Good, bad, different lordship. Kindly hear me. Okay, if your lordship is not hearing me, practically we are going to die.
This is something for the tribunal to decide.
Already superannuated.
Only when the tribunal is deciding, then you can come. We will not take up an issue.
I would have been blessed. The order would have been against me.
We don't know.
At least the first council.
How they can proceed? How they can proceed when you are behaving this way? You take a liberty. You want to amend the prayer. You don't take steps, and then you tell us.
35 orders. Lordship is looking only at one order. 35 orders have been adjourned.
Because this is
re-adjourned.
This is the recent order. This does not deal with the other 30 orders prior there.
Now, subsequent there to there
an order passed in July 23.
If they choose not to write the same, can I be at fault?
We don't know. That's not something to be raised before a higher form. The law is very well settled. But if an order does not take into consideration, you have to tell the court. You cannot come here and complain.
Ignore that aspect.
So don't make such a submission.
Ignore that aspect. Only thing what I am on. If your lordship ignores that aspect, what remains?
We'll see.
If your lordship too ignores that, you use up that aspect, what remains? Still, I am in the same situation which I was on in 2016.
Therefore, we ask you to come clean. Where have you taken steps? Where have you said that you took steps? Still, it is not being proceeded.
Every steps has been taken. Lord, can he take up all the matters?
After this, nothing has been done.
No, or can he take up? As per modification is concerned, when we said we are not inclined, therefore this other orders was passed.
You please read this order slowly. The state has raised an issue regarding maintainability of your OA. You say that, you don't say that, no, it is maintainable, I want to proceed. You say you agree to the submission and you say, now I will modify my prayer. You are acceding to the objection of maintainability.
No question of.
Please read, then make a submission.
Yes.
Please read, then make a submission. Yes, now read. And now you make no amendments and you want us to hear it as it is when you have said you will amend the prayer, acknowledging that it is not maintainable.
Liberty is going to file a supplementary application to the effect that the prayers of the original application, no query was put on behalf of the state that this is non-maintainable.
You please read the entire order. If you choose to ignore, that will not erase anything from
Liberty
the
is
order.
also given to the applicant side to pray for filing of the application by all applicants collectively through one application.
As prayed for, liberty is given to the applicant. Please read paragraph 4. As prayed for, liberty is given to the applicant side to file a supplementary application to the effect
that the
prayer will be modified. This you are making a prayer when you are faced with an issue of maintainability. Now you want to get over that and argue the case as it is.
Let me kindly be with you.
Very nice.
This maintainability issue was not on that day. I'm coming when it was issued. Initially.
We are not going to consider it like this. This is an acknowledgement of the point that your OA was not maintainable. You wanted to modify it. And now you want us to consider it as it is.
If the OA is not itself maintainable,
yes,
the order was passed from this High Court.
Correct.
To decide the issue. Correct. Therefore, the question of maintainability
this order
goes on that
this order will not get effaced from the records. This order was never considered by the High Court. And it cannot be ignored today also.
Maintainability order. I'm just give me 1 minute. This was initially argued in 2016. Not this. This was the first time. আগের অর্ডারটা আছে পরিষ্কার যেটা হয়েছিল just 1 minute. This issue was there from 2016 itself. আগের দিকটা WPST 60 ওটাতে আছে পাওয়া গেছে Got it, Mal. This was in 2017, Lordship. Yeah. Only I'm having a one copy of it. Can you? I touched. Oh, Lordship may have another one is there. It's, this was a 2017 order. This was not on that day.
Which order?
Yes, this one, 2017. Question of maintainability was taken up on that very day. After subsequent, the Lordship will find at least 35 orders were there for on the tribunal. This 2017 order reveals with the maintainability.
So this is the issue. You have acknowledged this issue.
No.
You say you want to amend.
Subsequent, there was no amendment. Subsequent there too, the matter was taken up by the High Court. The High Court was pleased to direct.
That we have seen. That you have already
Therefore,
shown us.
the question of maintainability and non-maintainability is no longer the issue.
We don't know.
Good, very different.
You may say so, but we don't know yet.
You may decide. Lordship, can you allow me to place the matter before your court?
We
This
are
is
not.
the only issue. Nothing else.
The only issue is whether the tribunal is at fault for not hearing the matter, or there is a contributory,
The Lordship will be taking.
or whether you have.
My only one point.
You
and
are
the
you're
issue is
you're
pending in
you're
2016.
correct.
That is no issue. And I am already armed with all the orders of the court.
See,
How
from
is the matter
this
taken to
order, it is quite obvious that you have filed an application, remained pending, maintainability raised. They say it is not maintainable. You acknowledge that submission. You say, now I will amend my prayer. Thereafter, you don't take steps. You start coming to the High Court. You got one order that expeditiously disposed. Now again, you have come. Now you want to circumvent or get over this order where you have acknowledged the issue of maintainability.
No.
You could have resisted then and there. You have not done so. Now we will consider this.
No, Lordship, kindly.
We'll consider.
Now, if your Lordship is of
We are being very clear because the record is speaking for itself.
the other records is not.
So therefore, that you have already said.
Those are everything in my favor. What I am beseeching before the court, can
We'll
you hear me?
consider whether under such circumstance the High Court should exercise
Yes.
jurisdiction or
See,
not.
if your Lordship is again pushing me over there, this will practically killing the matter.
So who is responsible for this? That is what we are to see.
At least we are not.
You may say so. You may say so. We are not stopping you.
And dismiss my that will make the situation.
Whether we are to exercise jurisdiction for such a person, we'll examine that issue.
Practically, I'm in a soup today.
We have seen the records, sir. We have seen the records. Court is not hearing you. You don't modify, you immediately thereafter come to the High Court. That is what you do immediately after taking liberty. You come to the High Court and then the High Court says expedite. Again, after 3-4 orders, you have come to the High Court.
Why High Court says
Therefore, in this circumstance,
aware,
whether we are to exercise jurisdiction, equitable or not, that we'll consider.
So can you hear me? Thereafter push me out.
We will not go into the merits unless we are satisfied on this aspect, that we are to exercise jurisdiction, and we don't find.
In fact,
we are being very. At least I am observing out loud from the records. I don't find that there is an occasion for this court to exercise jurisdiction right now.
If your Lordship,
if you had taken bona fide steps,
if your Lordship hear me for 10 minutes on the issue,
hear you.
Yes, Lordship, can you hear me?
Yes.
For a kind producer, she kindly takes up 126.
Where is that order that you had just passed on to us, that 2017 order?
I just hand it.
What is the date of that order?
20. Page, but this page 54. Page.
Can you give us copy of the order?
There are two. One thing which I intend to highlight for once. This was the erstwhile writ petition being filed, on the basis of which Justice Tandon's order was passed. Therefore, this was there. Subsequent thereto, the order was passed by the court.
Down. 27, 40.
You give us a copy of these orders.
Yes.
Then we'll consider.
And only one thing, she can.
After you place it on record.
Only one thing, this will be required.
Let the learned advocate
And,
on the writ petition. The record.
Great.
Yes. Let the
Next week,
let supplementary affidavit be filed within a week after due service upon the state respond.
Supplementary affidavit.
Yes.
Great.
Supplementary within a week, matter will come after 2 weeks.
Great. 3rd December. I don't want anything. I want to get the matter heard. Nothing else. Only thing.
That we understand what you are saying.
Nothing else. Because even
Yes,
that
call the
chance
next.
is not getting.
Call the next case. Item number 6.
Just saying that it is pending since 2000.
Till date, my lord's order, my lord, has not been complied with. Lord, my lord,
What is the order?
not to take any coercive measure. This is, my lord, from a transfer. My lord,
So
the
that
direction-
few days salary was.
No. Since September, my lord, I am not getting paid. Since September.
No, the other day Mr. Sen was saying that.
My learned senior friend was saying that, my lord, he'll take instruction. But I'm sure he has got the instruction that he is.
Where is he?
They're not getting the pay.
So can we proceed with the matter?
That, my lord, we can, of course.
Let us hear it
But,
out.
my lord, there was a direction upon us as well, my lord, to put in our reply. My lord, this is our, my lord, reply.
You already served.
No, my lord, I'm serving now. But with the salary, my lord, must come.
So let him, you are serving today. Then what we'll do is we'll just keep it not today. It will come on Wednesday.
Kindly issue a direction for payment of salary. My lord, I'm starving. I'm starving.
It will come on Wednesday. Let him come. See, if he was here, we would have asked him because he was very sanguine that day that it is being paid. He said that month's salary had not accrued.
Milord, I will wait for him. Milord, he was here.
That day he was saying that on the day it was taken up, that month's salary has not accrued. So there was no question of
That was,
paying it.
Milord, his submission. At the end of it, Milord, my learned friend submitted that, Milord, he will take instruction. Since you are insisting that, Milord, we are not getting payment. So, Milord, that was, Milord, his.
Yes, that we have recorded in yours. You are correct.
May I, Milord, wait for some time, Milord, for him to come?
Where is he? Let him come. Let us see what is the issue.
Yes.
Transfer.
Yes. Milord,
Group, this is that group D employee.
Yes.
Beyond the.
Milord, to the remote place of Darjeeling.
No, beyond the limit is specified.
Commutable, yes, Milord, yes. It's not commutable. And Milord, my wife is here, Milord, who is also working. So, Milord, this Milord violates basically two Milord circulars. One is Milord, spouse Milord must live together, and the other one.
How much enforceable that is an issue.
That's my weaker point. Milord, if I compare Milord my 2 points with one another,
that issue is being raised almost in every case.
True. That's weaker.
That is normally.
These stuff, commutable distance, Milord, I think we have a good case.
So now I remember his lordship was not there on that day, but now I remember merely because there was an issue of convenience, recognizing that issue of convenience, there was a policy decision and the transfer was being effected in respect of a group D employee.
Yes.
At the lowest rung.
Great.
Therefore, we were inclined to. Otherwise, in transfer.
My argument is concluded. Yes.
Otherwise, in transfer, I don't.
That's the case.
Interfere.
And now, Milord, in their opposition, Milord, they have come up with a Milord new plea. They say that Milord, those instructions are not binding on them.
That they will say something. We will see what it is, whether it is binding or not binding.
Well, my learned senior friend.
Serve a reply. Give the reply.
Yes, Milord, I have served. Milord, my learned friend has come. Milord, kindly. Yes, just back on page.
What Mr. Sen is not being paid salary.
We have annexed documents to show that.
That is very unfortunate if that is correct.
May I tell, my lord, there is some reason. And the reason is that if your lordship, my lord, kindly have a look, my lord, this is the, my lord, list of dates. একটু দিন না, my lord কে। আর কপি কোথায় গেল? ক কপি করা হয়েছে? আরে ওখানে 3 কপি গেছে। সমস্ত কাজে আমাদের দিচ্ছি। Madam, may I, lordship, kindly, my lord, for the first date 30th September 2024, that
Let's also have a look at the list of dates.
দিচ্ছি। 3 কপি করতে বলেছিলাম। That's, my lord, the reason. Now, my lord, kindly, my lord, come to, my lord, straight away. My lord, the 3rd January 2024, at the middle of the first page, Darnell WPAT Tribunal issues interim order stating that the employment transfer order is stayed until outcome of the original application 639. And the petitioner files contempt application CPN in the High Court Calcutta in a writ petition because the order was not complied with since he has not been allowed to join Dhaniakhali ICDS project is earlier the posting. In order of Honorable High Court disposing of CPN directing that the petitioner should be permitted to work at Dhoniakhali from 24th February 2025. This permission to join and work at Dhoniakhali will be subject to the result of the application pending before the WPST. And in the event the application challenging the transfer order before the WBAT fails, petitioner will be governed by the order that may be passed by WBAT. Petitioner shall also be paid the regular salary and other emoluments from the date of his joining at Dhoniakhali pursuant to this order. His past salary till the date of his release. Initially, there was a release order. Then, in view of the subsequent development of the High Court,
Give it back.
Now, my lord, so he should be paid regular salary from the joining at Dhoniakhali, my lord. Then 10th December 2024, past salary to be released as far as possible. Then petitioner joins Dhoniakhali. This is okay, 24th of February 2025. Then my lord, next page.
He has been transferred from which place to which
My lord,
place?
from Dhoniakhali to my lord Jorbanglo, North Bengal.
What is the date of that transfer?
The original transfer order was at the first page at the top, 30th September 2024.
Yes.
Now, my lord, he challenged the same before the High Court directly. High Court said file the tribunal before go to Taito. Watch. In any way, High Court said whatever the order we are going to pass, that order will be subject to the result of the pending away application. Then he was asked to join Dhoniakhali by the High Court. However, subject to all order to be passed there.
He was to join at Dhoniakhali. He was transferred from
He
Dhoniakhali.
was transferred from Dhoniakhali to Jorbanglo.
Yes.
Then, my lord, what happened? Then again, my lord, the order passed. Then the tribunal passed the initially stay order by the tribunal. Then the tribunal rejected. Then, my lord, after rejection,
Your lordships wanted to know of the High Court of this Honorable Court order. When the Honorable Court directed me to join, if within 3 weeks I am unable to obtain a restraint order from the administrative tribunal.
The High Court directed you to join if no interim order was passed, but within 3 weeks. Where is that order? Which
That's
date?
at page 127.
In WPA 30149. So from 2012-24, 3 weeks. Then what happened?
But the administrative tribunal was persuaded to pass an order.
Pass an order of stay. So you did not join. Yes.
then, my lord, kindly come to, my lord, the next page, my lord, the
Just a
second.
minute.
So then what is the occasion for coming here again?
They did not enforce the transfer order in that sense, but did not pay the salaries once again. So
From January itself.
I approached this Honorable Court through a contempt application.
Yes.
Now, not in contempt, in exercise of contempt jurisdiction, the court passed certain orders whereafter I was allowed to join at the
Dhoniakhali.
original place of posting at Dhoniakhali.
Yes.
And payment started.
Yes.
Till such time, the original application before the administrative tribunal got to be disposed of with certain observation.
On
that is one of
4th of September 2025.
Yes, the second page at the top.
And then the second release order was passed. Was issued on 8th of September 25. Thereafter, this Honorable Bench directed not to take coercive steps, which interpretation is now sought to be given, that we will not pay salary once again, but we go back to the stage when the Honorable Court exercised contempt jurisdiction in the first round.
One of the petitioner second release order at the minorities, second 8 September 2025.
Yes.
The petitioner was released from Dhoniakhali because of minority.
Where is that order?
That order at page 145. 145. The last paragraph. You are hereby directed to report immediately to the Chief Child Development Project Officer, Jorbanglo, Darjeeling, for assuming your duties there at without any further delay. Your joining at the new place of posting shall be governed by the original transfer order.
Yes.
Now, my lord, again, Lordship kindly.
So this is of 8th September.
8th September.
And we have passed the order on 12th.
Yes, yes.
4 days thereafter.
After that. Now, my lord, my lord, the problem that has arisen, if Amar boita dao to. If your lordship kindly my lord, rule 94 of the my lord, this my lord, the service rules chapter 11.
So let us conclude the hearing today. Let us consider. Yes.
The problem is that now neither he is in the my lord pay.
We have understood what you are going to say.
Yes.
We understand what you are going to say.
Now the difficulty is that my lord, in terms of rule 94.
We understand you are allowing the procedural prescription contained in the service rule to prevail over the court's order.
No.
We have understood what you are trying to say. So let us hear the matter. We'll finally decide.
No, my lord, kindly. My lord, kindly. What I want to say is that, Lordship, kindly consider, my lord, I have not yet finished.
No, you are not finished, but we have read what you have given in writing.
My lord, may I, no, in writing?
We have read what you have given in writing.
Some extent instruction to me. Some extent instruction.
So therefore, that's why we said we understand what you are trying to say. It is very much clear below the tabular form what you have to say. Now we will consider how this is to be viewed.
After that, now my lord, the disbursing authority, what is the 2 days problem?
We don't.
Kindly direct.
We don't. We don't.
Direct that the main, who will be the.
We are hearing it today. Let us conclude the matter.
Now,
we'll see whether he is entitled to anything or not. Whether he is entitled to an order, and if entitled to an order, whether he is entitled to any benefits or not.
We are not.
What kind of stand you are taking, and how you can argue such an issue?
My lord, may I tell you? My lord, may I tell? Today, may I tell you? My lord, kindly direct any my lord, the authority here and now, that to disburse this, that irrespective of the fact of his joining, then the matter will be solved. Lordship, kindly consider one thing. Because he has neither joined there nor here. The difficulty is that, my lord, he's who.
The point is, Mr. Sen, the point is, we have said no coercive action in September. We are in November. You have not paid him salary. Now whether
paid September from October. Yes.
That is right, because you say
September.
You say he was relieved on 8th September. Therefore, thereafter you have not paid him salary. You say even if you have directed no coercive action.
Difficulty, my lord, may I tell?
That is not your stand. That is not your stand. No, please read what you have said. Where you have said that there is a clerical or accounting difficulty. Just show us.
Here because it is list of.
No, but what you have said, read what you have said.
No, my instruction is
correct. You have to go by the instructions. So what is your instruction? Read the instruction.
Everything is not recorded herein, but my instruction is this, that the present moment, the difficulty is that who is his disbursing authority present moment, because after having been released.
How you can make a submission like this when this is not there in writing? Can we record your submission?
This is may I tell? On instruction. This is the whole difficulty. On instruction. This list of this task to show the chain of events, but not that what actually the problem. Problem is that unless again it is put on record in the my lord in the computer that his disbursing authorities and his payment is made from here, because after the release order.
Who is stopping you from doing what we don't understand? Who is stopping you from doing that? Every system, whether it is through the computerized or it is manually, it is ultimately controlled by the human. So if you have understood a particular order in a particular way, and you know that this is the consequence, who prevents you from
Kindly give some time. Only one at a time. Well, let it be, my lord. I take it personally.
So you take the supplement, the reply today, we will hear it on merit on the next Wednesday.
Not Wednesday, lordship. Kindly in the meantime, so that the salary matter can also be solved. So that, my lord, kindly give me 10 days.
All right, 2 weeks, next Wednesday.
2 weeks time.
Yes.
My lord, kindly, my lord, kindly. My lord, to bail me out. So, my lord, kindly pass online order so that this can be solved. Instead of only my
The
initiative.
matter, the learned advocate for the writ petitioner is serving. No, listing after 2 weeks. Up to 3 weeks.
Interim order টা কবে অবধি হবে?
Interim order 3 weeks মানে 10. Item number 7.
Should I appear on behalf of the state in this matter?
My lord, I'm appearing on behalf of the petitioner. My lord, I'm praying for not today. My lord, I'm praying for not today. I'm on behalf of the petitioner.
This is a writ petition seeking expeditious hearing before the tribunal. The matter is pending before the tribunal. Expeditious. In that even may it be kept day after tomorrow.
See, any matter which we are saying not today, it will come on Wednesday, because we are fixing Wednesday for these matters. So an adjournment is sought by the learned advocate.
Item number 8.
Item time for the petitioner. Item number 8, may I tell, before taking up the matter, this matter was taken up on 29th of October 2025. Matter relates to, my lord, non-disbursement of pension after even retirement. Thereafter, my lord, the one after another, my lord, way file, that, my lord, look, one after another way file, and in the last way, which is still pending, my lord, time to time order passed. And the last order passed, last two order passed, back-to-back order passed by the way, that directing, my lord, the respondent number 4, the director and ex-officio secretary to the Department of Agriculture, where he was employed therein, that to, my lord, they construct the service book again, and then, my lord,
Take
forward
steps,
the
consequential
same.
steps.
Yes, forward the same. But after that, what happened? Then, my lord, it was my lord's view and pass an order that so that I can come up with a report that after that what happened with regard to that, my lord, the disbursement of pensionary benefit, what steps have been taken. My lord, I was in the impression that initially, my lord, that the accountant general and they will say. Then, my lord, one after another officer I met with over telephone. Now, today, my lord, I am told today in the morning that Lordship kindly give some time, my lord, 2 weeks time. Then, my lord, I shall come back with the report.
So it has to be done by the state respondents. Service book will
Yes,
be with
yes,
you.
Yes, yes, yes.
Only after service book is constructed,
Then only
sanction
maybe-
order, then it will go
because
to the accountant.
otherwise there is no problem. So, my lord, kindly give me 2 weeks time. I shall.
2013
AG
petitioner
Bengal,
written.
AG Bengal ke
12
diyeche
years
কিনা
already
সেটা
gone.
AG Bengal ke
The
Get
3rd December or better to have it on 10th December?
10th December. On 10th December, my lord, I may have some difficulty, my lord, I may not be here.
You may not be here.
But I'm not sure, but that is why for abandoned precaution.
Then let it be on 3rd. We'll see. 3rd, let it be on 3rd.
Item number 9.
Item number 9, my lord, I am appearing on behalf of the state respondent. I praying for not today on behalf of Mr. Mansoor Alam, who is leading me in this matter. Kindly accommodate for the day, my lord. Yes. So 9, respondent number 9 is the private respondent. 8, only 9. 9 is also now represented. Has 9 appeared?
9 and 10.
10.
10, yes, 10.
There is a respondent 10 also. In the writ, there were only 9 respondents.
So subsequently 10 was added
In the writ.
in the writ.
So
Because
what-
10 has been appointed in that post. That's why it was the desire of the court to plead him so that he can be brought to the court.
No, but there is a order recording that they have been informed.
Yes.
They have already been informed.
Yes, yes. Informed. I sent twice. They accepted, none unrepresented. The state was directed to serve through district magistrate. That has been served.
Yes, on 18/11/24, the court has recorded that in spite of service, no one appears on behalf of 9 and 10.
Yes, yes.
In view thereof, for final hearing. So now they are not appearing, we'll proceed.
Yes, yes. Only
What
for final
what
hearing.
is the impugned order? Let us see what is
149.
order under appeal. Sorry, not impugned order.
Under 149.
Yes. Many writ petitions were heard together.
There only one writ petition and another writ petition was tagged. There are 2 writ petitions.
So what was your grievance?
My lord. My lord, the learned single judge, my lord, is of the view, my lord, that is finding of the learned single judge that I am the suitable candidate. I have been deprived. That is the observation. But since somebody has been appointed on the strength of subsequent notification, his appointment cannot be touched. And direction for enquiry with regard to, my lord, that is page 154. My lord,
And according to you, the selection was vitiated on what ground?
my lord, first selection, I was empaneled.
Empaneled.
Yes, I should have been given the appointment. My lord, appointment was.
So this is a regular appointment.
I was not given appointment. I approached this honorable court. That matter was pending. All on a sudden in 2020, that post have been filled up by somebody else. That is respondent number 10 by the respondent authority.
So another recruitment process was
Yes,
undertaken.
Yes. Well, since this writ petition
And
was
in the earlier recruitment process, when you were empaneled,
Lords,
you were not appointed on what ground?
on the ground that I am not the local resident of that post.
Which was a requirement.
But I fulfills all criteria. My interview letter shows that where I am residing, interview letter was sent to me. I accepted, I appeared in the interview. Everything is completed.
So is there any finding recorded by anyone that yes, you are a resident of that locality?
Yes.
Who has recorded that
The
finding?
single judge. No, they have recorded, they have not done anything. Only my appointment was withheld.
They have not said why.
Yes. In the writ petition, they first time came up with the saying that she is not the resident. Thereafter, it was affidavit reply, everything was done.
Can you take us to the averment in the reply before the writ court where they have disclosed?
Lordship.
At page 48, my lord.
Maybe page 50.
At page 50, the writ petitioner Nargis Khatun is not eligible by dint of her residence as being considered for Bhagwanpur sub-center as he is a resident of Abad Bhagwanpur sub-center under Abad Bhagwanpur Gram Panchayat. My lord, by considering this already there was an order on 6th May 2024 by Honorable Justice Somen Sen and Honorable Justice Uday Kumar to direction to produce the original file containing the application, because throughout the writ petition nowhere the original application or application filed by the petitioner has been annexed. Therefore, my lord, the original file is with Mr. Mansur Alam. Kindly, that's why I am praying for today's accommodation so that the record can be brought up.
And what is the date of the panel where you were empaneled as the third candidate?
My lord. Date is not there, but that is in the year 2013.
13.
3 on 3.
The panel was published in 13.
13.
And a second advertisement in 20 after 7 years.
7 years. Because selection after the panel got approved in 2014, appointment made in 2016. I approached this court 2017.
But you did not challenge the subsequent advertisement.
No, I have not challenged because this matter was pending. I brought to the notice of this court by my lord saying that since this appointment is going to be held and if somebody is appointed, my claim will be frustrated. This honorable court is of the view that since matter is pending, if you succeed, you will get the appointment.
There is an order to that effect.
No. Well, several occasions I asked for interim protection. That was also, my lord.
Any application to this effect was filed?
Yes, application was filed.
What is the CAN number or whatever it is called?
আমরা subsequent যে application টা করলাম
in the before the writ court saying that look, advertisement is issued, please state or pass an interim order protecting my right. Because the learned single judge's order does not take notice of any such application being filed. So even it is filed, then it is perhaps it is not either not pressed or not moved. Otherwise, it would have been considered by the honorable single judge.
But the learned single judge, your lordship kindly sees page 153. starts from 152. The last, the state respondent went for a subsequent selection process for unfilled vacancy of Bhagavanpur and Abadbhaganpur by publishing a fresh advertisement. That is there. 30th June 2020. Anita and Suraya BB, the respondent number 10, read petition, participated in the selection process, conducted in fresh selection. Anita Sardar Naskar became successful in respect of the vacancy of one sub-center under Abad Bhagavanpur. As submitted, has not been given appointment. The added respondent, namely Suraya Khatun, has been selected and given appointment pursuant to the selection process held in terms of notification 30th. In the aforesaid facts and circumstances, there is no vacancy in respect of Bhagavanpur Sub-Center at the present. It will be harsh at this stage if the appointment of Suraya Khatun is set aside, holding that the entire selection process under 2020 notification was vitiated. At the same time, it will be unfair to Nargis Khatun, appellant, being the petitioner in such and such, if due to arbitrary steps taken by the state, a selected candidate who is otherwise eligible for appointment is deprived of the same. No relief, however, can be given to Nargis.
So there are two things, therefore two things we are asking you. One is from where this conclusion has been recorded that otherwise she was eligible.
Yes.
Who found that this objection was not sustainable regarding her not being a resident of that local area? Where is that finding?
Yes.
At what stage? When it was recorded?
My lord, may I place the finding on 51 last paragraph. In another petition, such and such found Pinku Mistri. These are I am skipping. Now, in view of the aforesaid, the vacancies, last three lines.
Yes,
in view
yes.
of the aforesaid, the vacancies of Bhagavanpur Sub-Center in one of the.
Oh, her name appears in the voter list.
Yes. Center were not filled up. Nargis Khatun BB, the petitioner, as appears from the voter list. Such and such with regard to Bhagavanpur PP school polling center, is a voter of such constituency, as such was entitled to be considered for Bhagavanpur. It also appears from the letter issued by the state respondent calling the petitioner for interview that she had applied for Bhagavanpur Sub-Center under Mathurapur. Despite such clear admission that Nargis Khatun had applied for Bhagavanpur Sub-Center, it is inconceivable as to how her candidature could be rejected on the ground that her residence was not at place for being considered. Now, question is, somebody has been given appointment.
What is the fault of that person?
That is the situation now. That somebody has been appointed.
Again we are asking you, if you have taken adequate steps, if you have filed an application seeking stay of the subsequent recruitment process or an order by the Honorable Writ Court that you please protect my rights, but there is no such application.
In the paper book, there is no such application.
No, even in the order, his lordship has considered everything, but he has not taken notice. So in your appeal, have you said that can was filed or any application was filed for?
No, because that was not considered, that was not placed.
But that is the only issue. See, you have been wronged. That has been held by the single judge. But for the wrong, what is the remedy? That is the issue. The Honorable Single Judge found the only remedy is that somebody can be identified as to why he has done this. You cannot get any relief by way of appointment because it is already filled up and that person cannot be removed. So your appeal is limited to the remedy. You don't have to establish that you were wrongly not considered.
My deprivation, that cannot be washed out. My deprivation, I was entitled to have my job.
That Honorable Single Judge has held that you are entitled. He has found that you.
Therefore, only my lord.
No, that therefore only because an appointment has been made can you be deprived. So only the issue is whether the remedy is correct or not. Right has been established that you had a right to be appointed. You were a member of that locality. You were resident. All that has been established.
Yes.
Now, what is the remedy to be granted? Now, for remedy, if you have not acted with due diligence, then can you say that the order is bad?
No, order, my lord, partially in my favor.
Fully in your favor. The order is recognizing your right.
Right,
Therefore,
absolutely.
it is fully in your favor. But the
Therefore-
remedy, it has become, due to subsequent events, the remedy has become unavailable to you in the terms that you wanted the remedy. So another remedy has been said that you identify the officer who is responsible and conduct an inquiry. This has been held by the.
that is there, but my appointment will not be suffice on that remedy.
That we understood.
But my
So
right
therefore-
accrued in 2013.
So the only thing is to be seen is whether this conclusion is sustainable or not. So what is the law? If first thing is the panel's life is limited. In this case, you are the admitted position is 2016, the panel was published. Final appointment made. Now, at best, the panel will be available for 1 year. So 2017, the panel would have lapsed as per general law, unless in the service rule it says otherwise. Advertisement has been issued even 3 years after that in 2020. At that time, your writ petition was pending. From the record, it appears you have taken no steps for safeguarding your rights. Then how that relief can be granted? What is the option?
My lord,
Only issue of law. Facts are not in dispute. They have not challenged the single judge order. So they cannot say anything against it. Findings are all final and binding inter partes. Now, whether this relief could have been granted in this circumstance, that is what we are asking you. Let us see the law.
Somebody has been appointed afterward, whether he can.
Not only that, when you have taken no steps.
My writ petition is pending. I am waiting before this honorable court approaching that my right should be implemented.
Correct. That we understood. That you need not impress. The point is when subsequently after your filing of writ petition after 3 years, advertisement was issued.
That is done by the state illegally. The state
Correct.
action
Maybe illegal.
absolutely illegal.
So what steps you have taken, that is the point. You know that your writ is pending. It is a public notice inviting application for the same post which you are claiming. So what steps you have taken? Therefore, we asked any application has been filed. Writ record is with the LPA records.
Yeah, that's it.
The writ record is with this appeal. The writ record is with the appeal. Huh? It doesn't come with the appeal. Should be. No. No, must be, should be with the appeal. No. Then only it will come. So let us see the law then. Nothing, no facts are.
Lordship, kindly grant me 1 week time. By this time, I shall search for the authorities so that it can be.
An argument has been.
Next Wednesday. Next one. Wednesday.
Item number 10.
My appeal. I'm late by
Transport Corporation.
Calcutta State Transport Corporation, CSTC. So the petitioner is the employee of CSTC. He was the employee of CSTC and CSTC is the main business.
You are appearing.
that I am appearing on behalf of the appellant led by Mr. Partho Saruthi Bhattacharya. But the appellant before your lordship, he is, my lord, a superannuated employee of CSTC, Calcutta State Transport Corporation. Now, my lord, the dispute, my lord, pertains to rejection of my claim to avail pensionable service. It is my specific assertion that I had exercised option in 1991. It is the case of my employer that no option was exercised. Now, my lord, in order to substantiate my submission, my
So
lord,
prior to 91, there was only CPF.
yes, there was a non-pensionable regulation in vogue.
In 91, they came out with a
90
regulation,
Yes,
and those who wanted to opt for pension, they would go in the pension scheme.
yes,
Otherwise, CPF.
yes, subject to exercise of option. Now, my lord, I seek to, my lord, rely on, my lord, a resolution of, my lord, 29th of September 2000, wherein, my lord, of, my lord, my employer, wherein it was categorically admitted that although 97% employees of, my lord, the depot had in fact, my lord, exercised option, but those option forms were misplaced. And, my lord, it was also recorded that the factum of submission of option form can be, my lord, ascertained from the register maintained and kept at the concerned depot. Now, my lord, when this particular resolution was shown to the coordinate bench of your lordships, my lord Justice Boshak was, my lord, the honorable division bench presided over by my lord Justice Boshak.
May I interfere just one minute? But this is the fresh new point taken in the appeal. That is why, my lord, we have used an affidavit.
Yes, yes. My lord, liberty was granted to me, my lord, visit the office of my employer and, my lord, inspect the records and find out the register. Wherein, my lord, supposedly, my lord, this factum of submission of form is recorded. Now, my lord, I visited twice. Ultimately, they provided me, my lord, they handed over me a copy of a communication specifically indicating that even the register is also not traceable.
Not traceable.
Yes, my lord, that I have brought on record by way of a supplementary affidavit, my lord. In the event your lordship may kindly takes the trouble to look into the supplementary
All
affidavit.
right, we take it. Whatever you are submitting, we take it.
So, my lord, now the situation is not only the appellant before your lordship, but none of the employees who had, my lord, actually exercised option at that point of time.
Oh, here there is only one person.
One, my lord, they will never be able to, my lord, substantiate the factum of submission of option because there were two documents. One, the option form. Second, the register. Both the documents are lost.
Where is the 2000 resolution?
Yes, page 146, my lord, of the stay application. But may I place it for your lordship's consideration?
We'll read. Just allow us to read.
First three paragraphs, my lord, I am seeking to rely on.
Last order, please.
Yes.
And it is my duty, my lord, to point out to your lordship that in 1991, when the first notification was issued inviting exercise of option, my lord, there was, my lord, no system or methodology of, my lord, giving any acknowledgement of receipt, which they took note of, my lord, in view of this loss of option forms. And in the
What is
subsequent
the date of your retirement?
my lord, I had retired in, my lord, 2000, on, my lord, 30th of June 2006.
So if you had given an option, all those who had given option in 91, their GPF must have started.
Yes. They received, my lord, lump sum amount, my lord.
No, they must have deposited their CPF and GPF account must have been opened.
My lord, yes.
So all those persons who had exercised their, was that made available to you?
My lord, I could not follow your lordship, my lord.
Once an option is invited, prior to grant of pension, they must be covered by a CPF scheme. Once the pension scheme has come into vogue, they must have been required to surrender the CPF and GPF account would have been opened. So at that stage, you did not raise any dispute in 91 that why my GPF is not being deducted.
Me, I tell. Retired in 2006. Now, my lord, as a CPF contributory under the contributory provident fund scheme, my lord, all his, my lord, CPF benefits paid after
retirement.
Yes, everything paid. Everything paid. In 2014, a writ petition was filed and stating that no, I also opted for pension. When this pension regulation came,
Very well. We'll come back. We'll come back. We'll come back. Give it, give it. We couldn't locate because the case number was not there. Have you informed the other side? Just give the number, we'll see if it is not signed. No, that when it comes, you do it. Just right now, just give the case number so we know which file we are to search. Oh, not signed yet. There must be in the chamber. Water goes in a separate file. Keep it. Correct.
Item number 10.
Yes, my lord, the resolution which I have, my lord, just now, my lord, demonstrated before your lordship, my lord, my additional submission is, my lord, that neither this resolution nor, my lord, the information regarding loss of, my lord, option forms was, my lord, ever intimated to any of the employees who had exercised option in 1991, or, my lord, neither, my lord, any opportunity was granted to them to, my lord, submit fresh application forms. I was completely, my lord, oblivious to the existence of this, my lord, resolution. It was never disclosed. My lord, in 2010, my lord, 4 years before filing the writ petition, I wrote to them, my lord, which your lordship will find at page 120 of the stay application. Lordship may kindly straightway comes to, my lord, the second paragraph. Please.
So what was the last date for making an application? Option.
Last date, my lord. Lordship, I have to find it out from the, my lord, notice inviting, my lord, option, which is, my lord, appearing at page 148. This is, my lord, the notification pursuant to which, my lord, I had exercised option. The scheme will be implemented. On or before 2nd of October 2001.
So in the writ petition, have you stated that you filed your application before this date?
Will find my lord positive assertion at paragraph 21, page 40.
21.
21 of the writ petition, page 40 of the stay application.
So that. See. Here. See the last sentence of paragraph 22.
Yes. My lord, I had also exercised option. My lord, I belong to the lowest echelon of service. I was a fitter. My lord, I was asked by the, my lord, officials, senior officials, that you come and exercise option under the EPS scheme also. So I complied with the direction.
What is EPS and what is DCRB is of course the pension. What is EPS?
My lord, employees pension scheme, my lord, which is also, my lord, as I understand, is a pensionable scheme.
So that dues you have got.
No, nothing. I am not receiving any pension.
No APS, no DCRB, nothing.
APS, no DCRB.
And here you are claiming DCRB
DCRB.
benefits.
My lord, in my humble submission, my lord, this is, my lord, perhaps a fit case, my lord, to apply, my lord, the principles of adverse presumption. Because the employer, my lord, they are withholding the best evidence. My lord, first they say that the option forms are lost, but the fact can be ascertained from a register. Now, when I visited their office in 2024, they say even the register is not traceable.
And your date of retirement is?
My lord, 30th of June 2006.
And you moved the High Court in 2014.
2014, my lord. My lord, previously, prior to my retirement, my lord, I was pursuing another writ petition, my lord, assailing an order of arbitrary demotion, in which I succeeded.
That has nothing to do with
No,
this.
nothing to do with this. The least, my lord, involved in this writ petition or the appeal.
That we have seen. That has nothing to do with this.
No.
So 2006 you retired, you did not get anything, you did not do anything.
No, I did not.
For 8 years.
No, in 2010, my lord, I wrote to them, my lord.
Where is that?
My lord, 120, page 120, my lord, the letter, my lord. My lord, the second paragraph of the letter, my lord, I had specifically mentioned that I had opted for DCRB 1991.
Only after that meeting took place, then you started taking steps. Yes. So what is your submission? Yes.
My submission is, my lord, first of all, this is, my lord.
So after 2000, when you made this representation, they did not respond.
They did not respond, my lord. I, my lord, kept on, my lord, writing to them. Your lordships will find, my lord, letters of 2013, my lord. I am not troubling your lordship.
From 1 to 13, you were writing representations.
Even in 2007, my lord, I had written to the state government, my lord. But that letter is not with me. But the response, my lord, I have been able to find out. And, my lord, it is annexed to the stay application, page 95. They had, my lord, partially withheld my leave salary, and, my lord, the pension was also not disbursed, my lord. So I approached this honorable court by way of an interim order, my lord. The leave salary was directed to be paid. The order has been complied with. Now, my lord, by dint of, my lord, the order under appeal, my lord, my claim for grant of pension was turned down. 99.
What is at page 95? You were showing something at 95.
Yes. 95, my lord, is in response to a letter, my lord, addressed by me. This was issued by the Joint Secretary Finance Department to the Managing Director of CSTC, my lord, regarding, my lord, non-release of retirement benefit in favor of the appellant before your lordship. Not the state government in the Department of Finance directed the my employer to, my lord, release the, my lord, retiral dues in my favor.
Oh, that you are claiming under EPS. That is with reference to EPS. Because up to 2009, you have been raising claim for EPS only.
Yes.
No question of any DCRB. So why EPS has not been paid?
My lord, according to them, my lord, I did not submit any option pursuant to the, my lord, circular dated 24th of November 2004, which is appearing at page 145. My lord, this was, my lord, the applicability was restricted to, my lord, employees who did not attain the age of 56 years. My lord, I was 58 years by then.
This is for EPS.
EPS. According to them, I did not, my lord, exercise any option pursuant to this circular. My lord, I could not, because this was only for employees below 56 years. I was.
Did you challenge? Did you challenge this circular that it is not applying to you? Why it is not applying to you?
No, I did not challenge it, my lord.
So, admittedly, 2411 was not applicable to you. Therefore, there was no question of paying of any NPS scheme.
Yes.
Now, as far as the DCRB scheme is concerned,
But, my lord, from the pleadings of the writ petition, my lord, I find that pursuant to, my lord, the EPS 95, when I believe it was introduced in 1995, my lord, an option was once again, my lord, exercised.
no, see, this is of much later date. This is of 2004.
Yes, yes.
Two years before you retired.
Stand they took before the learned single judge.
Where have you said in this? Come to your representation.
My lord.
Page 92. Where have you said that any application was made earlier for EPS?
No, this was, my lord, I find for grant of pension under EPS 95.
So prior to this, there is no application. In this, where do you say that you have exercised or you could not?
This was, my lord, issued
in 2004.
2009.
9, yes.
9.
Much after the 2004 circular.
4. And
Yes.
subsequent to my superannuation.
Yes.
My lord, the first line says, I applied for EPS 95 during my service period on 20th of November 2003.
Yes. How could you apply on that day? Was there any option at that time? Because the first document that we are seeing is of 2004.
I do not find any document to that effect, my lord. I'm being candid to your lordship, my lord.
Because prior to 2004, there is no invitation for submitting any option.
Must have been, my lord. It was introduced in 1995. That is why it says, my lord, the nomenclature is
EPS 95. Yes.
May I only, my lord, on
Yes.
adverse presumption, my lord, on the principle of adverse presumption, my lord, may I only rely upon, my lord, two judgments, my lord, one of the Honorable Supreme Court, my lord, this is 2010-11 SCC 108. My lord, this is in the context of an election petition, my lord. My lord, the principle which has been laid down, my lord, is that failure to produce documents, my lord, by the custodian leads to an adverse presumption in terms of section 114 of the Evidence Act. Paragraph 29, my lord, is what I am relying on. And 30 also.
Paragraph
29 and 30, my lord.
29, 30. Yes.
My lord, another judgment, my lord, by a coordinate bench of the Honorable Court of your lordships. May kindly allow me. This is, my lord, 2018 5 CHN 20. Oh, and my lord, equivalent citation is 2018 2 CLJ 160. Paragraph 16, my lord. My lord. This, my lord, in the realm of service jurisprudence, page 16.
Hmm. Yes.
And I say, my lord, that there was, my lord, no conscious abandonment of any existing legal right.
You are referring to which paragraphs of this?
My lord, in this judgment, my lord, I am referring to paragraph 16, 1(6).
Yes.
And there was, my lord, no conscious abandonment of any existing legal right on my part.
Yes.
But kindly, we look at the, my lord, the impugned order passed by the civil judge. But that is at the
Yes. We'll go through it. We'll go through it. We'll read. Where is this? You see page 2 of the order. The CST authorities informed the petitioner that he was not a member. Where is this letter? This is referring to which?
'99.
For EPS benefit.
you have not contributed any amount. Because of the patient under EPS 95. Before retirement, then knowledge of the legal was legal. The GST and the question is lost cases. I retain myself, like to
Retain myself.
be a member under the EPS 95 scheme.
So,
That means you continue in his development as a member of my law community. Now, the fact remains that in his retirement, I got a matching sum with regard to the community. I don't know that community funds scheme, right? Then my lord, he has to contribute for his my lord every month salary. And matching amount is to be contributed also by the employer.
that is the CPF scheme.
That is the CPF. Now, because of CPF and he was not restored
to GPF scheme, according to us, our final record. So he continued and he kept on the contributing the same.
So there was no scope for one person to have benefit of both scheme.
Benefit of both scheme, no. So, no, EPS, yes, the DCRB regulation, you have to have that on a DCRB regulation of CSTC came into my law effect or into condition was my law 1991. Then my law 6 months period was given. That they were wants to get that my law pension scheme on to enroll under pension scheme. Yes, to all. Of them in 2000 okay. And they have given the pension. Now who did not, for them, twice the scheme was my lord then modified only to open the window for the purpose of finding their completion again. And last time the window opened in 2002 March, and again 3 months time was given to all who were existing employees who had retired by the fact. Now, at that point of time in 2002, also our report says that again some employees they opted for pension, including some retired employees. The present petitioner of the appellant worship did not know. Rather, he said even in 2003 that he wanted to continue as a CPF member, contributed provident fund, and that is why he paid for pension under the 95 CPF pension scheme. Now, here also, my lord, the fact remains that he again, at least with some matching sum, he has to contribute under that scheme also. He did not. Now, under section 17, my lord, it's a my lord, is CSPC. My lord, they are, my lord, maintaining, my lord, they are, my lord,
Section 17 of?
Section 17 of the my lord, that is scheme of that my lord, that they are maintaining their my lord, the trust, provident fund trust. Because what about the collection? The purpose will put the trust.
And trust will invest somewhere.
Yes, yes. Right? The provident fund trust. Or you put the provident fund, sorry, the commissioner of provident fund. That I am not getting my 95 scheme pension. Now, the CSTC say that you have not paid or you have not contributed anything even under that people.
But he is having a CPF account number.
Having a CPF account number, we are also my God. We have to know under that 95 scheme, he has to not only apply, but they are also he has to say that I am ready to contribute this sum under that scheme also. Because whatever amount that could be disbursed after that.
So if one employee is not a member of EPS 95, will he have a CPF account number?
Yes.
Even otherwise? No, we are just trying. It is not clear. Therefore, we are asking you. EPS 95 is one scheme. Other scheme is akin to DCRB. Now, beyond these two schemes, if one is that is understood. But if one is not a member of EPS 95 or prior to introduction of EPS 95, they were having a CPF account. That was a contributory pension scheme, CPS.
71 scheme, then 95, but every time the option asked and subsequently again you have to contribute the message as per the scheme.
So they would have a CPF account even if they were not member of EPS 95.
Yes. But also entire amount. But had it been deducted something, then only it would be deposited in that purpose and you get that sum after deducting.
No, the mechanics is whatever it is. The issue is making of an application or option, whatever is to be done. Whether that is done or not, that is all that has to be seen. Whether yes, regarding DCRB or EPS, EPS also was based on an option. According to you, EPS was also based on an option. You say he has neither exercised option for EPS nor DCR.
Page number 92 to 95.
For EPS. That we have seen, that is of 2009. Yes. That is of 2009. And the prayer is for EPS, or prayer in the writ petition is for DCRB.
The representation made before the authority in 2010.
No, in the writ petition, he is
In the writ petition,
DCR.
The petitioner was an employee of the National Corporation who belonged to pre-1971 batch since he joined the corporation on 22nd January 1966. It is a settled law after the verdict of the Supreme Court that employees who join any organization prior to 1st April 1971, they had to submit the necessary option to come under the existing family pension scheme, and their case should the subsequent introduction of EPS 95 scheme is concerned, that was also subject to writing option a benefit under the same scheme. The petitioner declaring his certificate did not exercise any option, either seeking to become a member of that family pension scheme as above, or a member of said employees pension scheme 95, or of any other such scheme introduced by the central government that was told by the competent authority. Next, my lord, D. Though the petitioner by letter dated 10 November 2003, being annexed at P5 to the petition, followed by another letter dated 14 October 2009, claimed that he was a member under EPS 95 scheme, and as such allegedly was entitled to pension under that scheme, but he had never opted for pension under that scheme. The petitioner did never interact with the Provident Fund Authority with regard to his claim for submitting option under EPS 95 scheme, which is evident in the same petition. In reply to the petitioner said representation dated 14th October 2009, the administrative and personnel officer headquarters of CSTC by memo dated 2686 CSTC dated 24th of March 2010, being annexed at P9 to the petition, informed the petitioner as follows. With reference to your letter dated 14th October 2009 in connection with the prayer for pension under EPS 95, the undersigned is to inform you that you are not a member of family pension scheme and employees pension scheme EPS 95, and you have contributed any amount to the respective scheme, and as such you are not under the purview of any pension scheme, and as such you are not under the purview of any pension scheme under employees provident fund organization. It may be mentioned here that a circular was issued on 24th of November 2004, inviting application as per directive of RTF, the regional provident fund commissioner, from the non-members of PM 71 as well as EPS 95, waiting for coming under the purview of EPS 95, but you failed to take the opportunity. Now this office has no scope to consider your case, but you may move to the appropriate authority for inclusion of your name in the apportionment scheme. On having proper information, we may process your claim. Then, my lord, kindly come to the next.
Yes.
Talking to be going into the matter. So kindly consider where A, B, C of the
Now, the next page 141, the internal page 7 of the operation. Now come to the DCR. Now we deal with DCR. Now we deal with DCR, page 141. The respondent corporation for its employees introduced a separate independent alternative retirement benefit scheme under the name and style of CSTC Death Cum Retirement Benefit Regulation. In short, DCRB Regulation 1990, giving retrospective but optional effect from the year 84. Say DCRB Regulation or DCRB pension scheme is optional, that is entitlement to get benefit under the same DCRB pension scheme. She is subject to filing option by the employees within a specific period as mentioned in clause 6 of the same scheme. So, time to time, on at least 2 occasions, the corporation by circular extended time to submit such option by opening the window for such option for a further limited period. The petitioner did never submit any option seeking to get benefit of pension under the same DCRB Regulation 1990. Then, madam, next. The petitioner, in fact, neither had opted for family pension under family pension scheme existed in 71, nor opted for pension under EPS 95 scheme, and nor he ever opted for benefit of pension under the CSTC Death Cum Retirement Benefit Regulation 99. Petitioner never contributed any sum during his service tenure, either towards statutory contribution as is required to be done by member of EPS 95 scheme, nor he ever contributed any sum towards the pension scheme under the CSTC Death Cum Retirement Benefit Scheme 1990. Contrary to above, the petitioner, after his superannuation, took away with the entire provident fund sum that accumulated to his credit, including the employer's share of contribution, and also the gratuity amount under the Gratuity Act 70, not pensionable gratuity. It is pertinent to state that the employees covered by the DCRB Regulation 1990 are not entitled to the gratuity under 72 Act, but they are entitled to lump sum amount on the basis of ground. So, on the basis of this, my lord, the amendments, on the basis of the documents produced before the learned single judge, the learned single judge came to a conclusion that whatever the stand that was, my lord, highlighted by the CSTC, that was correct, and so, my lord, no order.
So irrespective of which is irrespective of the scheme that he may be covered by, is he not entitled to any leave salary?
Leave salary paid, I think. Leave salary paid. My lord, pursuant to a direction by interim order passed by this honorable court in my writ petition,
Dues have been paid.
leave salary, leave encashment has been paid.
So prayer B, therefore prayer B now it is infructuous. No, our attention
Prayer A
was
pertains to grant of my lord
leave salary.
Yes. Second one is release the leave salary. Yes.
So that is now
C and A, my lord. Release the ad hoc amount, another return.
C and A are substantially for the DCRB benefits.
Yes.
No NPS.
No.
No EPS is no EPS benefit is claimed.
Now, my lord, my lord, we are compelled to use, my lord, a short applicable opposition because of the fact that it you find that the taken in the appeal that there was a resolution, and in the resolution it was, my lord, recorded there that misplaced or, my lord, of the option of the employees, and it appears according to them that there was a register which is maintained on the basis of the submission of option recording. Now, my lord, in respect of that, my lord, kindly
opposition on behalf of respondent of all parties. In the subparagraph 3, Roman 3, internal basically for the first time in this appeal claims that as a result of such loss or displacement of option on the part of the respondent corporation, the appellant was denied the pensionary benefit, though he had exercised option. Now, paragraph number 6. Insofar as the appellant's contention based on the same text of discussion held by the chairman CSTC on 29th of September 2000 being annexed E to the CAN number 1 of 2022 in this proceeding is concerned, the deponent submits that the discussions recorded therein under no circumstances can be treated as evidence in support of the appellant's new contention as to the alleged loss of his option from allegedly filed with the respondent corporation under this year regulation 1990. And then, my lord, paragraph 8. Paragraph 8, if you lost it, 91. Paragraph 8. Paragraph 8, where the sentence starts from the middle, it appears. Have you lost it, my lord?
Yes.
It appears from the same paragraph number 3 of the same text of discussion held in a meeting dated 29th of September 2000 that a discussion was recorded that in the event of non-availability of such option form in the individual file of the employee concerned, the same might have caused for misplacement in some cases, and in those cases and in that event, the register available in the depot and the offices would be consulted. That was the matter, the language, it was there. Then, my lord, after the order of the division bench, my lord, during the pendency of this proceeding, my lord, kindly, they say that on disclosure of document, that means, my lord, otherwise admission of their fact. The my lord, let's kindly come to that particular later.
There is a supplementary also.
Supplementary affidavit, the appellant filed hearing to bring the record with regard to that letter, which we, my lord, supplied to them, our internal record, but we supplied to them because there was an order that without prejudice to the rights and condition of the parties, if there is a register, then let them have a liberty to search. So, in inspection. Now, out of the inspection date,
This court allowed them the limit.
Independence. That's very good. Subject to the my objection with regard to that, the fresh point, new point, and other thing. Now, because of that, my lord, the order, the independence of the proceeding, my lord, letter was issued to them to come on a particular day. They went there, and subsequently it appeared because our different depot, CSTC, there are so many depots. So, but eventually, my lord, it appeared that there was no such register in the depot. With regard to that, my lord, the recording of any such, my lord, the event of submission, because whenever we received at that point of time the option form that was placed in the, my lord, individual service file, and no register, but since it was, my lord, recorded there in the minutes of the meeting, that if there is that can be looked into. Then this letter was written on November 12, 2024 during pendency. If they have managed this letter, that this is for your kind information. On searching of official records, no such register has been found available at the office of the Chief Mechanical Engineer, Work Manager, Central Works. So far as our knowledge is concerned, page number 6 of their supplementary affidavit.
So far as our knowledge is concerned, individual type option was made to personal file of the concerned employee as and when obtained from the concerned employee at that time. So, it appears, I will also kindly have it, my lord, I think my lord and also my lord gone through the impugned judgment of the Rajit Singh in there.
So based on this, they are saying that an adverse presumption has to be drawn.
Now they say adverse presumption. Now, my lord, first of all, my lord, I rely on my lord 2017 column CC. My lord knows that judgment very well that my lord the Pepsi Road Transport Corporation.
Which one?
2017 column 2 SCC page 766. My lord, paragraph number 17, 18, 23 and 24. On the point that one has to comply in terms of the scheme. So far the pension scheme is concerned, and subject to if there is an option, then without option, my lord, then cannot be given or extended. You will already kindly have a look at paragraph 17. 18.
Oh, that point is, see, they are not saying that option is not to be exercised. Their case is, we have exercised the option, you have misplaced it. Since you are not showing, there should be a presumption in my favor and I should be deemed to have applied for. They are not denying the fact that they were required to apply. So the issue is whether an adverse presumption arises in the facts of the present case or not. That is the issue. They do not dispute that there was a requirement of option being exercised.
Now, my lord, before coming to that particular page of that particular resolution, I will kindly consider one thing, that until and unless the appeal is filed and is my lord a piece of document it was their simple contention. First of all, before filing the petition in 2014, their contention was that all along in my lord, the correspondences which were exchanged between the CSTC and the my lord, the evidence before your lordship, that it was a my lord, the beneficiary of PS 95C. The DCRP scheme opted and it was not my lord extended to it. It was not there. Now, in 2010, after 4 years after retirement and after having my lord obtained all benefits as a retirement benefit under my lord EPS, I'm sorry, my lord, the permanent fund scheme, after having received all the same, then he my lord submit the same and we reply to them. Then he filed the writ petition. And in the writ petition, my lord, that admixture was that, and yes, you opted for EPS 95. And we replied to that. And we categorically state that no, you have not opted for PCRP regulation 1990. Now, my lord, after this document having been obtained from, and he said it is in general not for all or everybody, but we kindly come to my lord, page number 147. Once again, lordship, because he laid much emphasis on these. Lordship, kindly come to my lord, page number 147. But before that, 146. Yes. 146, paragraph 3. The query of Chairman CSPC, CAO, KP clarified that though he has mentioned, it is known that availability of option form at this stage is quite impossible. That is, my lord, with regard to my lord, the at the top, you will also kindly have a look. At the top, with referring to the note dated 28 September 2000 of PLO KP regarding disbursement of pension on the basis of revised consent and the provision under CSPC employees PCRB regulation. This was in the context of this that some employee possibly their revised consent. It is not a case that we did revise our consent. This regulation or these minutes of the meeting or this meeting was held not for in general of all my lord the persons or employees my lord accordingly him that of information. It was a meeting for a specific purpose as it appears from the my lord at the top. Now, my lord, in that context, paragraph 3, from the query of chairman, he has been clarified that though he has mentioned in his note, something was mentioned in his note that is not before your lordship, not in our record. In his note, that availability of option form at this stage is quite impossible. But not for all, so you kindly consider, not for all. But the records kept in the register in the officer report are available. He further clarified that by the above sentence, he means to say above form might not be available in individual files all places and might have been misplaced. So it was discussed in the event, the register available. So, my lord, when the minutes of the meeting was, my lord, recorded that in the event the register available. So the members present and who participated in the discussion, which is recorded here, they were supposed to show that the register was at all maintained and was at all available. He cannot say that the register was available. Kindly consider, if language is in the event the register available in the meeting.
What is the date of this resolution? What is the date of this resolution?
The date was
2000.
2000.
Long before the LPA or writ petition. And this page 99 is issued in response to which application? Some letter of 14/10/2009. Where is that letter?
14/10/2009 letter
92.
92. It's a longest letter.
Your lordships have already seen that.
So,
appeal for pension under EPS 95.
The date your lordship will find at page 94.
And it was so in 2009, kindly consider now we say that because something is there in the resolution, in the notice, in the minute.
Therefore, we asked you before you at the time you commenced your argument. One can have benefit of only one scheme, either EPS or under the DCR. It is nobody's case that you can have benefit of both.
But both are subject to what I have
Exercise of option. So this page 99 is the response to his claim for EPS.
That's a very that 2009, 2000, it carries the date of 14th October 2009. The person retired in 2008. obtained all retirement benefits as a minority member of the CPF, Contributed Provident Fund.
Oh, but therefore, again and again we are asking you, because it is difficult to reconcile these two documents. This 14/10/2009 application is an application for EPS 95.
Yes.
But 24/3/2010 is considering a claim for his DCRB benefit.
Kindly consider one thing, that 24th of March 2010, the reply was against his mother letter dated 14th October 2009. The person who retired in 2006. Kindly consider one thing. After obtaining all retirement benefit as a minority member of the CPF, then he wrote for EPS 95, not for minority CRB.
No. This family pension has been mentioned in the letter dated 24/3/2010. Therefore, we were thinking.
Yes.
So it is family pension scheme of 71, not the DCRB.
Yes, family pension scheme. If he is entitled to family pension scheme of 71, then my lord CSTC has nothing to do. Then my lord, that was the reply given to him, that he has to, my lord, pursue the matter with the my lord competent authority. Yes, that is provident fund authority. Provident fund authority. But that pension is payable by the provident fund authority.
Since we don't have the benefit of a paper book, can we request you to give a list of dates of these correspondence in one page, please?
Certainly.
Yes. Hearing. So we'll conclude the hearing. You give the list of dates. We have heard the parties. The
Item number 11.
First claim raised in I feel only thing. My lord, my submission is that the judgment referred or relied upon, my lord, and including that particular section of the evidence act, that is not applicable, my lord. That may not be allowed in this.
Lord, I am appearing for the respondents, my lord, here. I am appearing for the respondents.
well, the next case has been called.
Praying for my lord. Praying for not today, my lord.
Why, sir?
The advocate of the appellant, my lord, came to the court, my lord, but due to his personal difficulty, my lord.
All right, not today. Not today. इसको उसमें रखना है, इसके पहले वाला फाइल सीरियल नंबर
Very
12.
Yes. You are for respondents.
Okay, my lord.
Union of India. And you are for?
For the Coal India, my lord.
And one option.
My lord, in this matter, on the last 3-4 occasions, my lord, the petitioner is not reluctant, my lord, to appear in this matter.
Let us see. We'll
My-
just let us see the orders.
আমরা লিখেছি
There is no appearance on behalf of the appellant. Stop. There is also no prayer for accommodation. The order sheet.
Lordship, due to his severe cold and fever, my lord, he is unable to attend the court. Lordship, pray for notice not this week.
Not today means Wednesday, next Wednesday.
Not this week. Lord.
Item number 14.
None appears on behalf of the appellant.
$15.
I for the respondent
But
member.
15 and 16, Mr. Collusion, we have the appellant and petitioner of his lordship. I am praying for only not this week, Mr. Lordship. It's a
All
new
right,
matter.
not today.
Deputy Upper Lordship. And 16.
Same. 17 products.
Item 17, 18.
Up to date. 1395.
अभी फोन आ चौदह हो रहा था चलो
Same order, none appears. None appears for either of the side, either of the parties. Next.
17, 18 সেপারেট অর্ডার না কি অর্ডার
একটা মধ্যে করে দেবো। একসঙ্গে আছে।
ঠিক আছে
আর একটা সাবমিশন পাঠিও না
হ্যাঁ
14 তাহলে কেস করে
next week.
I'm for the respond.
Now you are for the respond. Where were you? And you? You are for?
Item number?
Item number 14.
In 17, 18, none appears for the appellant only.
Not
You give your appearance. Call the next case.
Number 19.
For a short passover, Lordship.
Not today.
20.
The respondent.
1280. We can file this.
20.
No, 14. I had been here, but suddenly I went in. I just
Sir,
told-
please don't.
Sir, you are a seasoned
My lord.
counsel. You were not here. That does not mean whenever you come,
My
you
lord,
can make a
I
mention.
had been here long
That
time.
does not mean you can make a mention
No, I
whenever
went
you come. You wait till the end, then you make a mention. These
went.
are settled courtesies of court.
No, I went to.
Please wait. This is not the way that whenever you come, you can make a mention that I have missed the case. You wait till the end of the proceeding.
I'm waiting.
Check करो ना, check करो. Check करो, check करो. खुला है, check करो. You are for the union of contemners. You don't want to file any affidavit.
I have not yet received any brief, but so my lord, I have not yet received any brief, my lord, but I have been instructed to appear, my lord.
But notice was sent. There is a direction to serve a copy of the contempt application upon the contemners by speed post.
Assigned.
None appears.
My lord,
for
kindly
the-
direct them to at least serve one copy.
None appears on behalf of the applicant.
এখানে বসতে হবে। হ্যাঁ হ্যাঁ তোকে তো তুমি ওই স্ক্রিন ক্যান application can 1 and can 2 there are different so hopefully দেখে না দেখে এক্ষুনি ডিপার্টমেন্টে ডিপার্টমেন্ট থেকে
22.
Lordship, I am appearing for the respondent wife. This is the matrimonial appeal, Lordship.
I'm for the petition, appellant Lordship.
Lordship, sign, yes.
Lordship, I'm praying for not today in this matter.
Not today.
Not today in this matter, Lordship.
কালকে করবে তো? Today বলতে
Not today means it will come on Wednesday.
Next Wednesday. Okay, obliged, Lordship. Obliged.
23.
This is my application for contempt, my lord.
I am appearing for alleged contempt while led by Mr. Bandopatra.
জানো
My lord, order is page 17.
Two 49 the department.
Please, second copy.
Department. পরের ফাইল সেটা পরে এখানে 1161 1161 1161 1161 hearing শুরু হবে
Yes.
Well, this honorable court directed to complete the inquiry within 2 months and to pass the final order. My lord, they have challenged the order of the Supreme Court. Supreme Court appealed the order passed by this honorable court. Thereafter, I know they have not approached before your lordship for extension of time to pass the final order.
Thereafter?
My lord, this court directed to complete the inquiry within 2 months.
Yes, where is the order of the Supreme Court?
My lord, the next page. My lord, can- My lord, I'm clear, sir.
It is page 26.
Page 26, my lord.
Has not been disposed of.
Yes.
My lord, may I?
My lord, I am submitting before your lordship. My only submission is this, my lord. When this honorable court directed to complete the inquiry within 2 months, and honorable Supreme Court also did not extend the time. My lord, without extension of time by the order by your lordship, they cannot pass any order after 2 months. There is a contempt.
My lord, may
They have to approach before the honorable court to extension of time. They have not done so. Now they cannot proceed with the pass any order.
Have they passed the final order by now? No, my lord, not yet, my lord. And we are waiting for the cooperation of the petitioner, my lord. On 21st, my lord, we have sent him the advice of the Public Service Commission. We have filed an affidavit. My lord, not yet, my lord. We can file, my lord. We can file the affidavit, my lord, citing the entire chain of events, my lord. We have served them, we have not received the same, my lord. Then, my lord, we have to send it by the help of the police, my lord.
You have all the documents, my lord. Then my lord fixed to present all the containers. My lord, you represent. Learned advocate. All the have you understood?
Item 24.
My lordship, I'm for the respondent.
for the
praying for
appellant,
not
my lord.
today.
I'm for the appellant, your lordship. This is
My
the
lordship,
matter.
for praying for not today.
Yes.
Your lordship, I'm praying for not today. I'm for the respondent in this matter.
Why, sir?
I'm led by Mr. Banerjee, the counsel in this matter. He's in some other court, so for not today.
Let us give the paper. Oh, he'll be required. The single judge has relied upon decision of the Delhi High Court, and that has been affirmed by the division bench also.
But I do have that, but my lord, affirmation of the honorable division bench,
That has been noted by the honorable single judge.
the reported decision, my lord, is there. My submission to that effect would be, my lord, that did not consider, my lord, the Saint Mary's recent judgment of the honorable Supreme Court, though it was before.
No, but when there is a judgment of one court dealing with an all India statute, the committee of judge of decisions will require that we should go by that.
One thing, my lord, I'd be just pressing your lordship, my lord, the Saint Mary's recent decision, my submission will be only on 2-4. If my lord, friend, my lord, takes note, only on 2-4. If I am there, otherwise I'm out.
No, we have seen basic facts which has been placed by the learned advocate yesterday. Yes, there is a grant in it. It is established by the ministry. But all the members are private steel companies. It is not discharging any public function.
There, my lord, my
And the grant in aid would that bring it with?
That would not be my submission to do.
Uh,
But my submission would be only with respect to Saint Mary's. The Honorable Supreme Court says it may not discharge public function. It may not have the grant in it, but it still can be amenable to writ jurisdiction if it is guided by any statutory.
Correct. That is so. It's statutory has to be.
So this is what I just.
This is
read.
not a statutory.
I
Neither statutory nor it has control nor there is finance.
And I say that it is a this has got a statutory force, the sale rule, of which, my lord, I am being guided. I do have the evidence to show your lordship.
No, we are talking about this your employer. That employer, whether his existence is founded on his and it has any statutory basis.
Subject to correction, perhaps, my lord, that is not what has my lord held in St. Mary's. It says that the service condition of any party, it may be a private institution as well, if the service condition is guided by any statute.
So the judge.
My lord, another copy I do.
আমার করা দেখুন আরেকটা কপি আছে আচ্ছা আচ্ছা
Just explain.
But I'm just handing up your lordship another copy. I'm sorry, my lord. At this, but somehow I missed it. There you. I just request your lordship to see only the summing up portion at page number 69, paragraph number 69, which is at page number 23. Twenty 22.
Paragraph.
Paragraph number 69. My lord, my lord, kindly pardon, my lord, I have got a part.
Oh, you gave us only one copy. So here the Supreme Court has upheld the decision of the single judge that it is not amenable to a writ jurisdiction.
Yes, my conclusion is that one. My lord, Lordship has seen 69 third.
69?
Paragraph number 69. My lord, here because this is different, my lord, in the SEC online and the truth. So, my lord, paragraph number 69 says we may sum up the final conclusions as under.
Yes.
So there your lordship will see the third paragraph of that.
It must be.
Yes, it must be consequently held that while a body may be discharging a public function or performing a public duty, and thus its action becoming amenable to judicial review by constitutional court, its employee would not have the right to invoke powers of the High Court conferred by Article 226 in respect of the matters relating to service where they are not governed or controlled by the statutory provision. An educational institution may perform myriad function touching various facets of the public life and in the societal sphere, while such of those functions as would fall within the domain of public function, public duty, be undisputedly open to challenge a public function, public duty, open to challenge and scrutiny under Article 226 of the Constitution, the actions and decisions of solely within the confines of ordinary contract of service, having no statutory force or backing, cannot be recognized as being amenable to challenge under 226 of the Constitution. In the absence of the service conditions being controlled or governed by the statutory provision, the matter would remain in the realm of the ordinary contract of service. So this line, I was relying upon, in the absence of the service conditions being
Controlled by government. So if there is no control, it will not be.
Service conditions, my lord, there is a service condition.
You said that even if it is not performing a public function, it would. That is not said here.
I'm sorry, my lord.
You said that even if it is not performing a public function and the person is employed, it can be amenable. That is not what it says here. In fact, it is to the contrary.
I tell you,
It says one that it has to be discharging a public function, and the other thing is it has to be guided by statutory rules. Then only the employment issue can be raised. And considering these facts, the single judge said that it was not amenable. The division bench allowed the appeal, and the apex court has upheld the single judge's conclusion.
Tell your lordship. Once again, my lord, if I just can place that part which I've already.
Please do it again. You read for yourself, then you place it.
Yes, yes, my lord. While it's in the middle of the paragraph, it starts while such of those functions as would fall within the domain of public function or public duty be undisputedly open to challenge the scrutiny of Constitution. That means, my lord, where there is public function or public duty, it would be undisputedly open to.
Yeah. Now the second part.
Now, my lord, the second part comes.
Undisputedly open to challenge. So that is the first part.
Yes, yes, yes. And scrutiny to say the actions or decisions taken solely within the confines of ordinary contract of service having no statutory force
Cannot be recognized as
cannot
amenable.
be recognized as an amenable to challenge.
So-
Means, my lord, subject to correction, my lord, the action or decision taken solely in ordinary contract of service where there is no statutory
Cannot be.
statutory, rule.
Cannot be recognized as amenable to challenge.
Yes.
This
So
is
this
settled
is
law.
what I say, my lord. This is not only an ordinary contract of service, rather
It is.
It
is.
He is protected by the cell rules, which is a statutory rule and is in force.
Where is that?
But that your lordship will see.
Where you have said that in your writ petition? Let us see.
Writ petition I did. So this is why I took an application under Order 41, under Rule 27 before the honorable before this one. This honorable court allowed my application, and my lord, there, my lord, I have annexed the document and the other documents as well.
They have filed any opposition to the order?
They raised no objection to that.
Paragraph 17 of the writ.
No. They have not filed any.
There is no objection to that.
All right. So therefore, we will consider that additional. Where is that additional evidence? It's part of the paper book. Which page?
But this application, my lord, your lordship will find starts from 110. The relevant, I'll just take your lordship. It starts from 110, my lord.
Where is the rule? Which annexure?
120, 120. It is not a rule, my lord. It is a mail communication. I'll just take your lordship just through one line of the mail communication. My lord, if I can please.
Just a minute.
I'm sorry. The last line of the last but one line of it.
Yes.
But this on that aspect, my lord, my writ petition was initially, my lord, for I made a prayer to the authority that you, if you say that if you do not have that rule, particular benefit of that rule I prayed, and that the rule is a beneficial rule, my lord, for the employee or the dependent on the employee. So, my lord, the department said, sorry, the respondent, my lord, they say that this rules will not be applicable to you. There are different sets of rules for our organization. I prayed before them that what are the rules for your organization. So that was also not provided. Thereafter, my lord, I filed the writ petition. one of the prayer of the writ petitioner for the honorable single bench was, my lord, for providing, my lord, with the relevant rules and everything. That was also not, my lord.
Why didn't you file an RTI application?
The date of the RTI application.
Why did you not file an RTI application for this purpose?
But I, my lord, made representation and thereafter, my lord, made legal notice as well.
No, why did you not file an RTI application?
That, so, my lord, that is my second part of my argument. I did not say, my lord, state within the meaning of Article 12.
Yes.
Article 12. So I say, my lord, this is, even in spite of the fact not being a state, is amenable to it.
How this document helps you?
This document, my lord, is
INSTAG says it has its own rules.
It says that
Yes,
from now on,
from 1922, you are saying by inference, it means earlier it was governed by, so earlier it was governed by what?
my lord, no more by the said rules. That means, my lord, it was by the said rules. My lord,
How it can be.
this is what I will just, my husband, my lord, passed in 2021. My lord,
And your substantial claim is for what benefit?
my lord, that benefit it called employee, it says, it calls, my lord, Employees Family Benefit Scheme, EFBS. But this is a very beneficial scheme. It says that during the service, the employee passes.
Anybody in INSTAG has got this benefit? Is it your averment in the writ petition that anyone?
That, no.
No. When you are claiming a benefit, you say it is applicable, then somebody must have got it before you.
But I can only say one thing here. My lord, the authority provided this benefit. My lord, this scheme says that if
Where are your prayers in the writ petition?
yes, but one thing, my lord, just pray. But the benefit says that if someone dies during the service, then his dependent will be paid with the remuneration for the left out period of the service. So that is the benefit, that is the scheme. So now, my lord, in this meantime, after my
So is SAIL reimbursing the salary being paid to you by INSTAG?
no, my lord, it is not.
SAIL is only giving a grant in aid
The Ministry
to
of
INSTAG because it wants this consortium or whatever association to continue with promoting consumption of steel. It is actually, it is driving the consumption for the benefit of the steel industry. Maybe there is a predominant participation by Joint Plant Committee and all these organizations. Several steel producing units must be members of this. This has nothing to do with government.
And my lord, after my prayer is made, they said that they will be giving me 8 lakh rupees pursuant to that benefit.
They will be giving
8 lakh rupees for that benefit.
For what
as
benefit?
a special case.
So they have given you.
They said that they will be giving me, my lord, 8 lakh rupees as a special case.
Where is that?
That your lordship will find that I have annexed in the writ petition.
So have you got that benefit?
No, I did not. My lord, they said that they will not be giving the entire benefit as per the scheme.
Whatever they are giving, did you get that?
Received.
So you have resisted the amount by saying that I will take everything. That is your stand.
Because that is my prayer.
No,
Yes,
we are trying to be clear on facts. Yes. So it is not their reluctance to pay. You don't want to take it because you think that if I take it, my entire claim will go.
Yes.
Now, where is their offer of paying you 8 lakh rupees?
That your lordship will see. Take your lordship. Page number 50. It says that there was no rule, but as a special case, I'm giving it.
So this was during pendency of the writ petition.
This is part of it. Malad, this is all my submission about this, Malad, because I said that if he Malad said to be maintainable, Malad, I could have just made that clear. This is all my submission.
Yes.
Malad, the writ petitions prayer, if your lordship is into.
Take your lordship, leave and come back.
Commanding the respondent, each of them, to pay a sum of rupees such and such in terms of the still. The first and foremost figure, it's a money claim under a particular scheme. So it's a completely a disputed question of fact whether he is entitled to this, computation of this, and applicability of the rule. Presuming for the moment the writ do not lie against me, I am not doing any public function. Then lordship kindly turn to the next. Commanding the respondent, each of them, to consider the representation of petitioner dated this in accordance with the law of sale rule. So lordship, it is presumed that this rule is there. Issue a writ of certiorari such and such. So primarily a money computation. Make the rule maintainable, they are coming up with a part that you told that you will make me something. It's no matter whether it's he works in a proprietorship firm or a company or in a society, some payment is always due. We will write to him that yes, we will consider your case. So my agreement to make a payment cannot give it a writ court jurisdiction. This is my first submission. Now lordship kindly turn to the page. Lordship kindly come to page 34. Type copy start from 34. Then lordship, according to this calculation of this page 35, which is type copy page 35A, lordship, we have made payment. Now kindly turn to page 40.
What is 34?
34 is the benefit scheme, which is typed next page, 34A. Lordship, kindly turn to.
This is applicable to him.
That is what he is saying. But whether through a writ jurisdiction he can make a mandamus on me or not, that's a separate question. But I am trying to show first that I am clean. Now kindly come to page 40. Please be informed that the gratuity of such and such, calculation of the gratuity, I have calculated. Please find here with a check such and such of 20 lakh. Because 20 lakh is the maximum gratuity. Page 40. And you see how he has taken my advantage. 20 lakh is the after amendment of the Gratuity Act. That's the maximum amount he could get, and we have given him the maximum. Now, lordship, kindly turn to page 41. It was his prayer that the son may be absorbed. Lordship, what we are doing. Employment of Sri Atul Sagar Puri. Although there is no such provision in the instant, we submit the prayer to our working group for a favorable condition. Working Group deliberated favorably but declined the proposal of considering the candidate of thesis and his profit and background do not match with the instant line of activity and requirement. However, on a compassionate ground, working group and such express their willingness to evaluate the candidature of such and such in their prospective organization based on requirement, if any, and accordingly to this. Now, Lordship, I pause here for a moment. What is my working group? Lordship, I am a Society under Societies Registration Act 1961. And who are my members? My working group member are SAIL, Jindal, Tata, all steel companies are my members. So anything happens to me, I report to them. My lord, my one employee is unable to carry on. Then they sometimes absorb in their organizations. That should not be equated with a compassionate appointment given by the government or the local government. Now, Lordship, kindly turn to.
So he was employed.
Lordship, we tried when we have forwarded the name to all of my members like Jindal, Tata, everywhere. And then, Lordship, we also received the writ petition, and then probably my client did not pursue that. Because it's only matter of persuasion. Because chairman, CEO, and president of each big companies are my members. What is my function? If your Lordship kindly turns to the function of mine, if your Lordship kindly looks into page. You have to help me. Show me page which you have annexed. Object clause.
Which page?
Object clause of the institute. You have annexed it. It was there in the rate. Malad, kindly turn to page 78. That is his admission. Lordship, can you turn to page 78? Institute of Steel Development and Growth is a non-profit member-based organization established by Government of India, Ministry of Steel, Major such and such, in the year as a society under the Societies Registration Act. Established in the line of Steel Construction Institute, UK. The institute primarily works towards development of advanced and cost-effective design methodologies, techniques, and institutional marketing by expanding application of steel in different segments of construction industry, upgrade of the technical skill to know-how, creation of awareness amongst the potential user and student, and communicating the benefit of steel vis-a-vis other comparative material. Instack is also involved activity in formulation of revision of code and standard of steel used in construction based on latest development in Bureau of Indian Standard and Indian Road Congress. Apart from the Ministry of Steel, our founding member are all major steel companies like SAIL, Tata Steel, JSW means Jindal Steel Work, RINL, AMNS, Instack are efficiently networking relationship amongst the member organization for exchange of idea on steel related knowledge. Presently, Institute is having following membership category on primary, associate, institutional, individual, life, and student. Detailed eligibility for each criteria are available under the members vertical. So, Lordship, basically what I am doing, I am a 1961 Societies Act registered. I am coordinating with the bill stick companies so that the idea can be formulated, awareness can be. I now put this question to myself, am I discharging any statutory duty? Lordship, for that we have to see only in Calcutta, writ lies against CSC, Calcutta Electric Supply Company, which is a private company. Why? Because the judgment says that it was the duty of the West Bengal government to provide electricity in the city of Calcutta. Like Salt Lake, Newtown, we all get it from WBACDCL, West Bengal Electricity Transmission Company. But such facility is not there within the city of Calcutta. So a private company is playing that role of a government. Therefore, the writ will lie. So someone has to substitute the act of a government. Lordship, I am not doing any act of a ministerial job or any act of a government. Against SAIL, yes, PSU, writ will lie. Against Tata, writ will not lie. So, Lordship, on the first occasion, we said.
Yes.
Sorry, Lordship.
Yes. We are hearing, don't.
So, on the first occasion, I said that I am a society under registration act. So, the writ will not per se lie against me unless you show that I have a general public duty performed. Lordship, this is their own document on which I am reading. This document shows that my primary function is whoever has promoted me. That's a separate issue.
Yes.
Lordship, so whoever has promoted me is not the case. It's the case whether I'm discharging the public function or not. So, Lordship, the function which they have described in their writ petition does not come within that purview.
Where have they described the function?
Lordship, they have described the function at page 78, 79.
No, that is a document. In the
That
writ,
is the document
in the
they rely
pleading, in their pleading, they have where they have said anything.
Forget about their pleading. I am extending, giving them all benefits of doubt. They can pitch their case this high, that even whatever comes from the document is treated to be a pleading. So, the Lordship, if this document they are relying on, even in that case, Lordship, my act is no public act.
Well, that's all.
Lordship, a private tutor who is teaching, that will also come within the purview. This is my first. And second, Lordship, if your Lordship kindly takes the single bench order, it's a Lordship, it's at 80, starts at 82. The Lordship, the similar question is tested by another High Court. I am not looking into any persuasive value.
Where is that judgment? Delhi High Court judgment?
Lordship,
There is a judgment of Delhi High Court relied upon by the learned single judge.
Lordship, I placed it before. Lordship.
You placed it before us.
I placed it before single bench, Lordship. Unreported.
That's why we are saying there is a judgment, and the learned single judge has said that it has been affirmed by the division bench also.
Yes, Lordship. I took those.
So where are those two judges?
Lordship. She's.
Both are there, only single judge or division bench also.
Single judge and division bench. If you look, I'll hand over the single.
So this is the division bench.
Yes.
The division bench, my lord.
Very well. So this is good enough.
And this is the single bench also.
Lordship, against the same institute, the question has been tested by. Now, this has got a persuasive value, Mala. And it has been detailedly, discussion is held. Fund holding, activity, whichever I am arguing.
হচ্ছে তার মধ্যে এটা সিঙ্গেল ডিভিশনটা
So this was not carried higher, this division bench judgment?
No, your lordship. No, your lordship.
Lordship, kindly come to para 4.2 and 4.3 under paragraph 16.
What are you referring to?
Lordship, looking into single bench.
No, you want us to see the single paragraph?
Paragraph 16, which I was just placing before your lordship from the document primary, secondary membership. Now, lordship, kindly look into your bill 4.2 and 4.3. For overseas organization, annual subscription will be 2,000 only. Ministry of Steel, Government of India may not require to make any annual subscription. So that is all we are giving a honor to the ministry, because we are on the background. Now, Lordship, kindly turn to 17. Paragraph 17. Lordship has got it. Now, 11.1. Roman 2. Corpus from the Ministry of Steel or member, associate, honorable member or institute members. So their Ministry of Steel is lying at the same footing with Tata, Jindal, everyone. Then interest from the corpus and other funds. So source of income, kindly see. The fund of the associate can be utilized towards the object of the association or any other purpose. So it's not like that the Ministry of Steel is giving me some extra money. So they cannot have a control on me.
Yes.
Now, Lordship, kindly turn to para 20.
Yes, we have seen that.
Lordship, now Lordship, kindly see para 21. Equal contribution.
Nine point one,
Yes.
paragraph 18. Have a look.
The general management of council shall be vested in the executive council meeting, and council may be held anywhere in India and shall be held not less than once in a 6 months with certain such each year, continuing with annual general meeting of the.
So control also vests in the executive council, not with the ministry.
Right. Now, Lordship, kindly see the finding of the court. Your Lordship, now kindly turn to 30 paragraph. It is not the case of the petitioner that the function of the respondent number 1 organization or the relief sought by him in the writ petition has a public law element. Even on that ground, the present petitioner shall not be maintainable in view of the conclusion. Lordship, now kindly see how the division bench has dealt with this. Now, Lordship, kindly come to the division bench. There are 6. I'm reading 6-9 of that para 6. What I exactly argued was not performing any governmental function which could be regarded as essential public purpose, closely related to the government sovereign function, or being fundamental to the life of the people. The respondent claims that it does not perform any statutory duty or obligation towards the public at large. The respondent claims that it is a society constituted by the private and the public sector organization. There is no deep pervasive control of the government over the management and the affair of the respondent, and there is nothing to show that the sources of funding of the respondent is from the government alone.
That is your submission. That's not the court's finding.
Finding. Then finding on this court. That's what I'm saying. Now, Lordship, kindly turn to paragraph 27. I have shown this from the single bench orders. The source of the income of the instance is primarily from the subscription from the members, associate and other. No doubt a substantial surplus has historically been made by the government into the corpus of the respondent. And the amount has been contributed as grant in aid by JPC as well. The interest on the corpus and other fund, income from the reserve service remark, consultancy provided, publication and other form of income generated by the utilization of its fund towards the fulfillment of his object is to be done within the approval of the Executive Council President of this. The accounts of the year such and such based on record show that out of the total contribution received aggregating this, about 30%, that is contribution has come from the private.
Yes, we have seen. We have seen.
So, Lordship, so far as my fund, and then my duty, it's clear that I have nothing towards the public as a whole as a duty. Because public at large has nothing to do with the steel industries.
That's all. Heard.
Ask your lordships to consider in these judgments, your lordships, if your lordships also sees the division bench judgment, my lord, paragraph 38, where it says that
38.
Paragraph 38, my lord. Paragraph 38 of this judgment, my lord, and paragraph 26 of the single judge's order, your lordship, where it has been clearly stated that no documents have been shown to be able to show that there is a pervasive control. And the documents that has been placed are there. Two things have not been considered, my lord. First is the documents that we have relied in our application under Order 41.
So which document is showing any control?
Your lordship, the documents that we have relied upon in the supplementary affidavit.
Which document is showing that there is any control of the ministry?
Your lordship,
Which is that specific document?
My lord, specifically the document where your lordship.
The learned advocate who was addressing us earlier, he has shown us one document saying that by inference, some earlier rule was applying.
Yes.
There is no document placed that there is any control by the ministry.
If your lordship kindly.
Cost of interrupting also, Lordship, I should have pointed out. Lordship, this organization takes up the rules. They don't have a rule. Initially, when the fund was very good with them, we took the Jindal steel rules. Then, Lordship, moderately we took cell rule. Now we formulated our rule from which the later Lordship has. So, time to time, all the organization member, whoever is there, we take the rule which is more lucid to us, we take. So it's not like that I am fundamentally governed by that.
At the relevant point of time, the sale rules were there, your lordship. Also, because my lord, if your lordship sees two documents for the last time, my lord, I'll disturb your lordships. Firstly, page 40 of the paper book has been referred, my lord, wherein the gratuity they state has been paid to us of rupees 20 lakhs. They clearly say that it is as per sale circular.
All right.
So sale rules were prevalent at the time the employee is concerned, my lord. Thereafter, your lordship, but however, they do not apply, they do not give us the benefits of the employment benefit scheme, family benefit scheme, but gratuity under that sale rules have been provided to us. My lord, then page 122. That is one document that we had filed with our application under Order 41 Rule 2, my lord.
Page?
Page 122 of the paper book. The first point, your lordship, INSDAC to furnish detailed justifications for continuation of support from JPC and Ministry of Steel. Action plan for the same may be furnished to the ministry within 1 month. INSDAC to identify critical areas of gap in respect of steel consumption. New areas should also be identified for focus. INSDAC should engage with industry. Therefore, these actionable points have been considered and have been forwarded to Ministry of Steel to have a look, your lordship. That electronic mail is also there, my lord. Reply to that is also has been annexed, your lordship. An action taken report is being submitted to them, my lord.
Very well, he is here.
Apologize.
Here we have been taken through the judgment of the Delhi High Court, two judgments that have been placed by the learned advocate.
I started, my lord, my argument by saying that St. Mary's, my lord, has just relaxed the amenability of a jurisdiction of the court. If your lordship could, my lord, kindly appreciate that, and that we don't, my lord, just could get some benefit out of this.
No, but they have pointed out that they have paid 20 lakh rupees gratuity.
That's the entitlement, my lord, that she already had.
Plus an amount you are not taking is still available to you. Has that been withdrawn or it's still available for?
Instruction I don't have, but
No, if there is no instruction to the contrary, then it is still available for.
20 lakh, lordship has seen 20 lakh.
Yes.
So that also pursuant to the rule of the SAI.
That just now she has shown.
Yes.
gratuity, no more. My lord, gratuity is paid under the Gratuity Act 1972. Now the limit has been extended to 20 lakhs, so we have extended.
So they have relied upon some rule of some organization. That does not mean you are governed by them. They have adopted those rules for the purpose of their functioning. That is, it's not your case that you were appointed under the sale recruitment rules or that it was ever extended upon you. Because we have seen your appointment letter also.
Yes.
So it is.
That is not mentioned there. I
There's
also
no-
checked that.
Yes.
Only with respect to this GCRB benefits.
Hmm.
And my lord, the other service, including the gratuity, lordship has already seen. These are the, my lord, guidelines, the rules which are being followed by the IRNL and also, my lord, the SAI.
So where is the material to say this?
That only I could just assist your lordship with the mail communication, internal mail communication by which it said
All right,
from now on.
we'll give you 5 minutes on next Wednesday.